असा वेटिंग रूम मध्ये सुजाता म्हणून आहे. बगुल सर, लाइव स्ट्रीमिंग इज ऑन.
हाँ, ऑन कर दिया मैंने अभी. YouTube लाइव चालू हो गया. ओके अभी.
Admit. Should I admit everybody?
नहीं, रुको.
Bagul sir, please mute everybody.
काय होतं?
Mute.
1 वाजता
हो, आप कर दो. सगळ्यांना म्यूट करा.
सुजित, ते सुजाता मॅडम जॉईन झालेले नाहीये. त्या दुसऱ्या कोणतरी सुजाता मॅडम आहेत.
Admit. Should I admit everybody?
नो वेट जस्ट एकच मिनिट.
सुजित.
We'll mute. Everybody mute now. Mute.
1 वाजता
Good morning, everyone. Bar Council of Maharashtra and Goa welcome you all for the uh, late Advocate B Award Memorial Basic Legal Education Program. Uh, Friends, last year we had conducted the program, which was for the enrollment from January till March 2020. We ended the program with the hope that the next meeting session will be traditional one-to-one training session. Unfortunately, we were hit by the third wave and second wave, and therefore we could not conduct the training program face to face. However, Bar Council of Maharashtra and Goa passionately believes that dissemination of knowledge should be continuous, and hence we have decided to virtually inaugurate the second session of basic legal education program in the memory of late Advocate B. Award, sir. Friends, before we start, a small request to all the participants who have joined through Zoom app to kindly switch off your video. Since we are 1,000 participants, if everybody will keep their video on, then there will be bandwidth issues and network lags. So it is requested that please switch off your video cameras and please refrain from raising your hands. This is an inauguration function, where all the information are provided to you. If there are any queries, we will take it at appropriate stage. But right now, it is requested that please everybody switch off your video camera. Now, now we are now this we are 1,000 participants at Zoom and as well as on YouTube Live. So we must firstly thank everybody for joining in. Friends, now I request our Honorable Chairman, Shri Anil Govadipe, to address the welcome speech. Participants at Zoom and as well as YouTube Live. So we must firstly thank everybody for joining in. Friends, now I request our Honorable Chairman, Shri Anil Govadipe, to address the welcome speech. Friends at Zoom and as well as YouTube Live. So we must firstly thank everybody for joining in. Friends, now I request our Honorable Chairman, Shri Anil Govadipe, to address the welcome speech.
ये नीचे का ये चल रहा है, देखो ये माइक्रोफोन वाला, उसका माइक्रोफोन वाला वॉल्यूम कम नहीं, माइक्रोफोन अपना इसका आपका नहीं, अभी जो बात कर रहे हैं तो वहां पे आवाज आ रहा है ना।
एक घंटे में आ जाते हैं। and Chairman Bar Council of India, Honorable Sri Anil Singh, Additional Solicitor General of India, and our former Chairman Bar Council of Maharashtra and Goa, Honorable Sri Ashutosh Kumbhakoni Sir, Advocate General of State of Maharashtra, Advocate Sri Devidas Pangam, Advocate General State of Goa, Honorable Sri Jayant Jay Bhave, former Chairman, Honorable Sri Ashish Deshmukh, Chairman of Basic Legal Education Program, and Honorable Sri Satish Deshmukh, Vice Chairman Bar Council of India, Honorable Sri Avinash Awad, Member of Bar Council of Maharashtra and Goa, and all my honorable members and my young brothers and sisters from the legal profession who are newly enrolled in the challenging years 2020 and 2021. I welcome all of you for the inauguration of State of Goa, very Honorable Sri Jayant Jay Bhave, former Chairman, Honorable Sri Ashish Deshmukh, Basic Legal Education Program today. In the presence of all these dignitaries, at the auspicious hand of Honorable Sri Justice Abhay Oak sir, it is decided to start the 8 days training program for every enrolled advocate since January 2020. This is the compulsory training program, and unless and until this program is completed, salad issued will not be confirmed. This is not to be considered as any additional restriction on the profession, but this is a sincere attempt of the statutory body of Bar Council of Maharashtra and Goa to enlighten the newly enrolled advocate for understanding the practice and procedure required to start the journey of legal profession. The detail of training will be explained to the newly enrolled advocates. In this opening remark of welcome, as the Chairman of Bar Council of Maharashtra and Goa, I will first of thanks to Honorable Justice Abhay Oak sir and Justice Dipankar Datta for consenting to participate in this inaugural function, and also for consenting for publication of 2 booklets, which are prepared by the Bar Council for the young enrolled advocates. This training program will be conducted henceforth in the memory of great teacher of law and a very eminent lawyer and scholar of law, who was the former chairman of Bar Council, late Advocate Bhaskar E. Awad sir. After pandemic attack on the society in the last year, he was given many lectures in the pandemic situation by virtual program. However, unfortunately, we lost him in pandemic last September. Immense contribution was given by him for the lawyers as well as number of advocates who joined the judiciary. We have taken decision to conduct this training program in his memory. Also, we already started training program for the lawyer to explain the detail of judicial service by the course of judicial service as a career since last 10 years. Through this program, number of advocates have joined judicial services. We are continuously doing effort of training with addition of providing an opportunity to learn, understand the career of public prosecutor, which is also potential opportunity for the new lawyers in coming time. We have certain restraint for organizing physical training program due to this pandemic situation. However, now the Bar Council is fully prepared to join more than 15,000 newly enrolled advocates at the time in this training program, and this inauguration is the beginning of the new era of virtual training across the state of Maharashtra and Goa. We are thankful to Honorable Advocate Manan Kumar Mishra, Chairman Bar Council of India, for virtually joining from Delhi. We always appreciate and support the efforts of Bar Council of Maharashtra and Goa regarding training program previously conducted. I am sure that we will get a present support from the Bar Council of India for this new initiative training program also. Honorable Advocate General of Maharashtra, Sri Ashutosh Kumbhakoni sir, is the part and parcel of the Bar Council. Honorable Devidas Pangam, Advocate General of Goa, are also part and parcel of the Bar Council. Similarly, Advocate Anil Singh, Additional Solicitor of India, who is our former chairman in our Bar Council and the guide, I welcome all of them and appreciate their sincere involvements. I also welcome all the family members of late Advocate Sri Bhaskar Awad sir. And lastly, I also welcome all the young enrolled advocates in a big number joining this program on the virtual platform. The program will be followed with talk show in which all bar councillors will discuss important topic of challenges and opportunity before the legal profession in current time. In this program, I welcome all of you And I'm sure that this program will be a new step of training on virtual for legal profession. Thank you very much.
Thank you very much, sir, for your welcome address. As Honorable Chairman has stated that this is in the fond memory of late Shri B. Awar sir. So I request our former chairman and chairman of Blep committee, Shri Ashish Deshmukh sir, to introduce the great personality, late Advocate B. Awar sir.
Good morning, one and all present here. Chief guest of the today's function, Honorable Justice Abhay Oak sir, special guest and chairperson of this function, Chief Justice of Bombay High Court, Honorable Justice Dipankar Datta sir, the bar leader of the India, Senior Counsel, Advocate Manan Kumarji Mishra sir, Chairman Bar Council of India, Additional Solicitor General of India, Honorable Sri Anil Singh sir, Advocate General of Maharashtra, Honorable Sri Ashutosh Kumbhakoni sir, Honorable Chairman of Bar Council of Maharashtra and Goa, Sri Anil Govardipe sir, Honorable Vice Chairman of Bar Council of Maharashtra and Goa, Sri Sudeep Pasbola sir, Honorable Vice Chairman of Bar Council of India, Sri Satish Deshmukh sir, the Chairman of the CLEP Committee and the mentor, our guide and pillar of the Bar Council of Maharashtra and Goa, the former Chairman, Honorable Sri Jayant Jaibhave sir, and in whose memory we have arranged this lecture series, the son of late Advocate Bhaskar Rao Awar sir and the member of the Bar Council of Maharashtra and Goa, Honorable Sri Avinash Awar sir, all the dignitaries present here, all my dear participants. Actually, there is no need of introduction to late Advocate B. Awar sir. All of us knows the contribution of the Awar sir in the legal fraternity. But as this lecture series is in the memory of Honorable Advocate B. Awar sir, as a formality, I am going to introduce and tell you something about Honorable late B. Awar sir for the new entrants who are going to join this legal profession. It is my honor to introduce late Advocate Bhaskar Rao Awar sir, whom all of us call a Bhishmacharya of the legal education. Late Advocate Bhaskar Rao Awar sir was born teacher. He came from small village Chinsondi of Ahmednagar district. He was from an agriculturist family. He started his education in Pune, and after passing first year LLB, he started teaching law to his colleagues and junior students. Then the unending journey of academic excellence starts till his breath. He was gold medalist during his LLB and LLM courses. His award law classes has developed career of thousands of advocates. He shaped up career of few hundred judicial officers. All these have resulted in a great contribution towards the legal fraternity by such an outstanding devoted teacher. As an advocate, he practiced in all branches of the law, such as land revenue, tenancy laws, law of convenience, civil suits, educational law, criminal law, with many constitutional matters contested at High Court and Supreme Court at his credit. He was well known as a versatile lawyer. After implementation of the Urban Sealing Act, he was said to be the last authority on the subject due to his expertise. As a Bar Council member, he served for 10 years in the Bar Council of Maharashtra and Goa. He was the chairman of the Bar Council of Maharashtra and Goa and started many academic activities for new young advocates. As an author, He has more than 10 books on law, literature, and poetry to his credit. He was adorned with numerous awards, Puraskar like Samaj Bhushan Puraskar, Guru Mahatma Puraskar, Bandhutva Puraskar, Dr. Babasaheb Ambedkar Puraskar, Pradyavant Puraskar, Shikshan Bhushan Puraskar, Zinda Dil Puraskar, etc. He has delivered lectures on Doordarshan and Akashvani. He was a founder of Maharashtra Academy of Engineering Education and Research Institute, Pune. In lockdown, Honorable Award Sir delivered more than 25 lectures, webinars at the age of 70 years with commitment towards the fraternity. However, unfortunately, fell prey to the pandemic, got infected with the COVID and breathed his last on 24th of July 2020. Lawyer fraternity lost a Vatavruksha of the knowledge, an academician of a par excellence. One of the finest learned but humble human being from profession is disappeared from judicial scenario of this nation. His active presence for last 50 years was unparalleled. With many prestigious awards to his credit, he continues to be in the heart of the lawyers as a BE Award Sir. Bar Council, as a representative of 1,75,000 lawyers, acknowledge the great contribution of the Award Sir and has unanimously resolved to start the compulsory training program, that is Basic Legal Education Program, popularly known as Blep, permanently in the memory of Advocate B. Award Sir. His memories and contribution will be permanently remembered through this academic program. Path of academics and profession shown by Award Sir will take the new generation towards the heights of excellence and perfection with strong commitment towards a common man. We all salute Advocate B. Award Sir while conferring this program Blep in his memory. Thank you very much.
Thank you very much, Ashish Deshmukh sir. Now, friends, Bar Council of Maharashtra and Goa has prepared a booklet which contains all the necessary information which all the young lawyers require at their initial stage of joining the legal profession. So, hence, I request our chief guest for today, Honorable Shri Chief Justice of Karnataka High Court, Justice Abhay Yug sir, to inaugurate the booklet. Thank you very much, Lordship. Friends, we have Bar Council has also published a booklet where of judicial, which with revised booklet of judicial service and prosecutorship as a career. So I may request Chief Justice of Bombay High Court, Honorable Shri Deepankar Datta sir, to virtually inaugurate that booklet. Due to technical issue, Lordship is unable to join. I now request our member, former chairman of Bar Council of Maharashtra and Goa, Honorable Shri Jayant Jaibhave sir, to introduce the basic legal education program in the memory of late B. Award sir to all the participants who joined through Zoom as well as on YouTube Live.
Chief Justice of Karnataka High Court, Justice Abhay Yug, Honorable Justice Deepankar Datta sir, Chief Justice Bombay High Court, Chairman of Bar Council Maharashtra and Goa, and all the dignitaries on the dais, off the dais. all my respected colleague bar council members, and the new enrolled young advocate brothers and sisters. This is a great opportunity for all of us to start this training program in the name of late Advocate B. Awad sir, who was rightly said by Ashish Deshmukh as a Bhishmacharya of legal education. And the name itself, the name of the training program in memory of late Advocate B. Awad sir, uplifts the excellence of this training program, because Awad sir was a man of excellence. Throughout his education career, he was a gold medalist, and in spite of a high merit of a knowledge and excellence, he always delivered his services to the common man, from the advocate and students from village areas, small cities, and therefore his contribution cannot be forget by the legal fraternity. And rightly, therefore, Bar Council has decided to resolve that henceforth this basic legal education program will be conducted in memory of late Advocate B. Awad sir. I salute to this memory while introducing this very innovative training program, which is perhaps first in a time in a country that is in the nature of a basic legal education program. All the senior advocates and lordship are well aware that the apex court, in a judgment of V. Sudhir in year 2000, has expressed certain view about the training to the new enrolled advocates. It was a dispute when the Bar Council of India started 1 year training program prior to the completion of a LLB course. After completing the 4th year of pre-law LLB, it was a 5th year where a compulsory training program was introduced by Bar Council of India. It was with an intention that after taking the legal education, the lawyer who gets the sanat has to again be there in a waiting room for learning a practice. And therefore, it was a concept introduced by the Bar Council of India that let us start that training program itself from a 5th year of the LLB course. It was challenged, it was discussed, and 100 pages judgment has been given by the Supreme Court. After considering all the technical, legal aspects, all the necessity of the upliftment of the legal education, after considering that there is a bridge between the legal education and the practice, everything which we discuss normally has been discussed in that judgment. That judgment is a base for starting this basic legal education program. It was a judgment of apex court that it should be done by the State Bar Council, because as per the scheme of an Advocate Act, under Section 6, an enrollment is a function of a State Bar Council and not of a Bar Council of India. However, towards this training program, perhaps there was not much concentration. Bar Council of Maharashtra and Goa was fortunate to have a guidance from Justice Abhay Oak, from Justice Bhushan Gavai, from just former Chief Justice of the Bombay High Court, Mohit Shah Sahib, and many other judges like Justice R.C. Chavan, Justice Pukhraj Bora, many more judges, and the leaders of the bar, the Advocate General, the Solicitor General, and we started the continuous legal education program long back under the leadership of a former Chairman Raju Patil. That program was successful. I still remember when today's our guest, Honorable Kumbhakoni sir, has become a judge of Bombay High Court, and his first program was at Lonavala, when he has delivered a lecture in the first continuous legal education program. I still remember that every lecture started with the lecture of S.V. Kanitkar sir, until last program when he was hospitalized, he took the discharge and delivered the lecture. That was a commitment of the senior advocates of the bar. Honorable Justice Oak has each and every sessions of this continuous legal education has delivered one lecture on very important subject and preferably on the professional ethics conducts. That has given a different vision to the thousands and thousands lawyers through the continuous legal education program. It was the concept of a basic legal education program by considering the new enrolled advocates in front of the Bar Council. We always discuss that the legal education which you took in the law college is not sufficient to cop up the practice. The law is taught by the professor who is not aware of the practice, who is not aware of the niceties of the practice, and therefore the application of the law is not available with the degree, and therefore many times it is called that the degree of LLB after completing a course and taking a sanad is a hollow degree. In these particular aspects, we always tried to bridge these two concepts. Our chairman of the Bar Council of India is here, who has been always encouraging us to develop this concept. And therefore, now we are coming with this basic legal education program, which is a compulsory training for the new enrolled advocates, 8 days training program. Compulsory means we have issued a sanad with a condition, with a resolution that you must undergo this 8 days training program, then and then only your sanad will be confirmed. As there is a All India Bar exam, and you can take the sanad, but after going through the AIBA exam in a 2 years time, your sanad will be confirmed. Similarly, that restriction, reasonable restriction with a positive attitude that you should learn how to practice. And therefore, this basic legal education program has been designed. The program is to be divided into 2 parts. 4 days will be the physical training program, where camps will be organized at a divisional level or at a state level, and 4 days will be the online program. Today we are suffering from the pandemic situation. This is an area where only the positive things are said to be negative. If it is positive, everybody is afraid. But we are coming with a positive approach that in spite of pandemic, let us start with the training program virtually. And therefore, Bar Council has created a virtual platform whereby 15,000 advocates will at a time join the virtual training program, and we will be conducting 4 days training program in which near about 25 lectures are designed. And in these 25 lectures, we will give a basic concept of the practice. We have selected the topics, and this booklet which just now Honorable Justice Oak has published. In this booklet, you can find the index. It is divided into 4 parts. Basic topics of practice in a part A we have covered, where a read practice, interpretation of statute is there, standards of professional ethics, basic principles of criminal and civil jurisprudence we are covering, evidence, a concept of an evidence in a civil and criminal trial we are discussing in a part A. In a part 2, we are discussing with the basic topics of the civil trials, civil practice, where we are talking about the speedy civil trial. We are not talking only of the civil trial. We are talking of the speedy civil trial, because trial is hampered by delay. If a new generation has to give this practice of civil trial, they should see how the speedy civil trial can be conducted. So we are dealing with that topic. We are also dealing with the civil appeals practice and procedure. For that, in a part C, we are dealing with the criminal practice topics, where basic concept of the CRPC in light of the practice will be discussed. Then the criminal trial and how to conduct the criminal trial will be explained. Hard stages of reading the charge sheet, and from FIR to charge sheet, and from charge sheet to trial. These 2 parts are subdivided. Accordingly, the criminal practice will be explained to the newcomers. There is also another topic of criminal appeals practice and procedure. In part D, we are dealing with the basic topics for miscellaneous subjects, in which we are dealing with the specifically fact, we are dealing with the practical hints on matrimonial disputes, Consumer Protection Act, status of a daughter in a Hindu Kopashnari, Section 6, which is a much deliberated subject and much discussed subject on the floor of a bar council. We are considering that topic here. And also, lastly, we are dealing with the basic information required for the practice, such as basic judicial forums available for the practice, the different types of tribunals, the administrative tribunals and other tribunals, what are the legal websites searches available, and the various training program and the method of conducting this training program. In short, in this way, the basic legal education program will be conducted. I must inform to this August gathering that substantial fund received by the Bar Council will be contributed for this training program. And by using this entire funds, we have given these 2 booklets. All these booklets will be personally delivered to each and every enrolled advocate. Today, the Bar Council is ready to deliver to 15,000 advocates. In addition to that, we are preparing one practice guide for the new enrolled advocates. It's not difficult. Now it's a difficult time that you will get a senior. Even if you get a senior, in this pandemic situation, the senior is not going to on a front line. So the junior has to learn his own practice. So how to do that practice? What are the practical hints required? What are the drafts of the pleading? What are the basic short points for the law? Everything will be covered in this practical guide of a practice. That practice guide we are preparing, and another one booklet we are preparing, that is what is a Bar Council and what are the rules and regulations of Bar Council, along with the concept of the professional ethics, etiquettes, conduct, and also friends misconduct. Because now you are in a huge number, so you must understand what is the conduct of the profession. You must understand what is a misconduct expected under the Advocate Act, so that you will be away from all this misconduct. I will not take much time because today we had a great opportunity to hear all these dignitaries. Honorable Justice Abhay Oak will definitely guide us how to face this pandemic situation, how to go for the training. Honorable Justice, Chief Justice Bombay High Court, Datta Sahib is there. He is already working as a guardian of all of us in this very adverse situation of a pandemic. So he will guide us. He will show us the vision for working in this pandemic situation. And of course, our leaders, Anil Singh and Kumbhakoni sir, will also guide us. And therefore, I hope that, and I make an appeal to all the new enrolled advocates, you are facing a difficult time of the pandemic situation. We know that you have taken the sanat, and the entire profession, entire judiciary, entire world is affected by the COVID pandemic. You must be nervous in a mind to a certain extent. But friends, in Marathi we always called as Sankataमध्ये संधी शोधा. You find out an opportunity in a difficult times. And therefore this program will be followed with a talk show where we will be discussing the challenges which are there before the profession. We will be also discussing the opportunities which are available to your generation, your new enrolled advocates. Many opportunities are there. You can work from home also. You can go on a front line also. Be brave, take precautions, and fight out in this profession. That will be the message from all these dignitaries here. So I thank to Honorable Justice Abhay Oak and Honorable Justice Datta Sahib for giving us a time for this very important program, perhaps the innovative one, first in a time of a country, that is basic legal education program. Our leader, Nalan Kumar Mishra sir, is there at Delhi, and I'm sure that he will stand as a backbone for this entire training activity of Maharashtra, and will make this training program successful. Thank you very much.
Thank you very much, Jai Bhave sir. I now request Honorable Chief Justice of Bombay High Court, Shri Deepakar Datta sir, to inaugurate the booklet Judicial Service and Prosecutorship as a Career. Thank you, Lordship. Now I request Honorable Advocate General of Maharashtra, Shri Ashutosh Kumbhogoni sir, to address the gathering.
My lords, both honorable chief justices, other honorable judges, respected additional solicitor general Mr. Singh, respected chairman and other members of our bar council, my professional colleagues at the bar, including the new entrants for whom specifically and specially today's program is organized, ladies and gentlemen. Let me at the outset, in strict legal terms, say that without prejudice to my right to address this fresh blood of our bar at length at latter point of time on a subject of their choice, I'll be trying my best to finish my today's address within the time of about 15 minutes allotted to me. First and foremost, few minutes about late Advocate Shri B.E. Award, in whose memory we have organized today's basic legal education program. He was a very good professional friend of my father, who passed away recently. Both practiced in revenue courts and dealt with matters relating to what we loosely call land laws, such as Land Revenue Code, Bombay Tenancy and Agricultural Lands Act, Urban and Agricultural Ceiling Act, Prevention of Fragmentation and Consolidation of Holdings Act, etc., etc. In my junior days, I have seen both in action. In the Maharashtra Revenue Tribunal, we call it MRT at Pune. More often than not, opposing each other. It was a treat to see Shri B.E. Awad sir in action. He was a very formidable opponent, a lawyer par excellence. Though very soft-spoken, yet he was very assertive, firm, and clear-headed, especially fundamental legal principles crystal clear. In all probabilities, this was because he was basically an extraordinary teacher. The law classes he conducted used to literally overflow with students of law. I know so many successful lawyers and excellent judges who have religiously attended his classes and secured meritorious position in university examinations at the cost of being regularly irregular in attending their respective law colleges. In those days, college attendance in law college was not compulsory. It will not be an exaggeration to say that many generations, especially in and around Pune city, have been immensely benefited by the notes that he used to circulate amongst law students, which were preferred by them to even university prescribed textbooks on various law subjects. Most of the students have cleared the law course with flying colors using these notes, not the textbooks. Suffice it to say, at least for district courts in our state, he will always be remembered like his own personality, a legend who always stood tall. Now about today's participants. I congratulate all the participants, the future of our judiciary, not just for successfully clearing all eligibility criteria for joining the bar, but for choosing the best profession that I know, for developing a grand and great career both as a lawyer and as a judge. In this profession, in true and positive or constructive sense, because it was just now referred, positive has a negative meaning in pandemic. So I'm saying in constructive sense, nothing is impossible. A clerk in a solicitor firm has retired as the Chief Justice of India. A person who as a child had to walk every day more than 10 kilometers for just being able to eat a meal has worked as Advocate General of our state, highest law officer. We have numerous examples of persons coming from very, very poor financial and educational background becoming very successful and renowned lawyers. There are numerous reasons why I always refer to our profession as the best career option. Let me mention a few. Firstly, what is not expected to be successful in our profession. In our profession, to succeed, you do not require a host of things which are prerequisite for others. Let me mention a few. You do not need an excellent academic record or a background. There have been and still there are very successful lawyers and great judges who did not have an attractive academic track record. You need not be a gold medalist like Mr. Shri Award. You need not even be in the merit list. Still, you can become a very great lawyer, a renowned successful lawyer. You don't need a grand personality also, like a film star. Though you succeed on the basis of your oral arguments, you don't need an attractive voice quality like a singer, or for that matter, like Mr. Amitabh Bachchan. You don't need it. Financial investment, obviously, almost nil. You don't need a grand office with a smiling, smart receptionist to welcome your client to be a successful lawyer. I have practiced in Bombay High Court for 10 years using Bar Association's bar room as my office in the initial days of practice. Family background relating to field of law? No, not at all required. As I just now mentioned, we have two cases, one who became Chief Justice of India, the other who became Advocate General, and as we have, Mr. James Jadhav just now mentioned, example of Sri BE Award, not coming from legal background. Completion of education in English medium? No, not required. I will dilate it subsequently. So forth and so on. Then what do you need to succeed in this profession? Fire in your belly to always succeed. However, let me quickly draw your attention to what Shri Ashok Desai, the then Attorney General of India, once said, and I quote, "Succeeding is important, but succeeding within law is most important." Second thing, tremendous hard work. Whether you choose judicial service as a career or prefer to continue at the bar. I personally know that Justice Chandrachud, presently Judge, Honorable Supreme Court, not only as a practicing lawyer at Bombay, but also as a judge of the Bombay High Court, used to get up every day, including a holiday, at 4 a.m. and start working. So did Justice Abhay Oak. I don't know his present schedule, but when he was Bombay, he was getting up at 4 a.m. every day to work. There are many such examples. There are no shortcuts in our profession. Please note this. So do not search for a shortcut. This magnificent structure does not have elevators or lifts. You must go by the staircase, one step at a time, to reach to the top floor. Be patient. Art of advocacy and court craftsmanship cannot be learned overnight by reading books. There is no other way of learning these invaluable aspects of our profession, save except by the personal experience and exposure to rough weather, as also stormy situations, especially inside the courtrooms. Unshakable and deep-rooted integrity, absolutely must. Please remember that our profession is both brittle and brutal. You will never get a second chance to succeed. You have to always put your best foot forward. The competition is really cutthroat. You appear for an open to all public examination every day as you conduct matters in open courtrooms. Your performance is judged not just by the judge sitting on the dais every day, but by clients sitting behind you. On each such occasion, you have to give your best. You must see to it that nobody dares to raise even an eyebrow about your overall work, behavior, and conduct. Of course, my Lord Justice Oak is going to address today all of us on the topic of professional ethics, so I may not take your time much on this point. Stay focused. If you have to arrange priorities of your life in the range of 1 to 10, then you have to have at all places from 1 to 9 only and only profession. In the 10th priority, you have to fit in all others, be it music, drama, sports, tourism, etc. Since I am addressing all young entrants, let me make them very clear to them. Your first love has to be this profession. Anybody else will be a second love. What about language? I just now mentioned, it's not necessary that you must have completed your education in English medium. As I just now said, not necessary. Here you have two examples in front of you who have completed their schooling and education in pure Marathi medium. One is myself, and the other one, if I mistake not, is my Lord Justice Oak. Even for those who have completed their education in English medium, they have to learn what I always call as the legal language. Shri Bhausad Bobde, the father of our late Chief Justice Vinod Bobde, once told me that at his age, which was then more than 80 years, he used to read every day at least one full reported judgment, preferably of the Supreme Court, that too of 1970s, before going to bed. Please cultivate this habit, which from my personal experience, I can tell you, will bring about a sea change in the way not only you speak, but also in the way you think as a legal professional. One of the other angles of this aspect is that you must etch on your mind that your best friend in the profession is your library, whether e-library or a traditional library with lots of books. This friend of yours will never let you down. Without expecting anything in return, it will be a co-author of your success story. What about personal difficulties? Whatever be, should not come in the way of either your preparation or performance. Everyone has difficulties, but they should neither dampen your spirit nor presentation. सुखी माणसाचा सदरा आपण सगळेच शोधतोय, अजून कुणाला मिळालेला नाही. So don't look for it. Now the most sought after question, which is always asked me by most of the new entrants, where should I start my practice? Can I do it directly in High Court, or for that matter Supreme Court? I am of the firm opinion that every newcomer in this profession must start his practice only and only in district court. You must learn your basics, have your fundamentals very clear, have a rock solid foundation to build a beautiful palace of your career. Simple things like how to obtain instructions from client, both material instruction and actual instruction relating to the case. Prepare basic pleadings, even drafting of a notice, the procedural aspects, etc., all you learn in district court. I have personally put in 10 years in the district court as a district court lawyer. And I always proudly say, I am basically a district court lawyer. The only care you must take is to choose an appropriate senior. This is principally because spoon feeding is not possible in our profession. Henceforth, you have to learn on your own. Books like the one that are released today will only assist you in learning your own lessons. You have to do your own homework. Nobody else can and will do it for you. Now, the most important question, what about earning money? Of course, not even the sky is the limit. However, if you are after money in this profession, you will never get it. You must be after building an excellent career. Money will automatically follow. I may not at all suggest that you are all here to do charity. Though it is true that invariably the lawyer ends up in earning disproportionate to his efforts. But if you want to make quick money, then the profession you have chosen is a wrong profession. I think in a given time for today, this was an enough insight into our profession. This was like a teaser, not even a trailer of a film. दोस्तों, पिक्चर तो अभी बाकी है. I think for today, I have to conclude by expressing my deep gratitude to today's organizers of today's program for making me a part of it. I'm very much thankful to them and for all of you who have heard me carefully. Thank you very much.
Thank you very much, Honorable Shri Ashutosh Kumbhani, sir, Advocate General of Maharashtra, for your encouraging words. I am sure the new entrants into the field of law will take benefit of the useful tips provided by you. Now I request our other dignitary, Honorable Shri Anil Singh, sir, Additional Solicitor General of India, to encourage the gathering with his speech.
Honorable Justice Abhay Oak, Chief Justice Karnataka High Court, Honorable Justice Dipankar Datta, Chief Justice Bombay High Court, other judges, Shri Ashutosh Kumbhakoni, the Advocate General of Maharashtra, Shri Pangam, Advocate General of Goa, Shri Manan Kumar Mishra, the Chairman of Bar Council of India, Shri Satish Deshmukh, the Vice Chairman of Bar Council of India, Shri Anil Goardibe, the Chairman of Bar Council of Maharashtra and Goa, Shri Sudeep Pasbola, who is down with COVID, I am told, but he must be online, Vice Chairman, my friend Shri Jayant Jaybhave, the former Chairman and the heart and soul of this entire training program, Shri Ashish Deshmukh, the Chairman of Basic Legal Education Program, family members of Shri Award, members of the bar, all participants of Basic Legal Education Program, members of the bar, ladies and gentlemen. At the outset, I must express my happiness as this program is organized in the name of late Shri Bhaskar Award, who was a great teacher, a great lawyer, and a former chairman of the Bar Council of Maharashtra and Goa. I agree with the Advocate General of Maharashtra that Shri Award has made an immense contribution in the legal field, especially in the entire legal fraternity of Maharashtra. I will not repeat because already the Advocate General has spoken about that. The advent of 21st century has brought changes in the society. Lawyers, judges, and legal education have needed to respond and adopt to the fast changing times. The study of law must be tempered with commercial awareness along with legal skills, social awareness, and professional ethics. The legal education system needs to bring changes, keeping in mind this trend. The practice of law is a vocation where written and oral communication skills are vital and the future lawyers and judges must learn these skills when they join the legal profession and seek to constantly improve themselves to their careers. The Bar Council of Maharashtra and Goa has made the legal education possible to reach to everybody, with special emphasis on improving the standard of legal education so as to match the global standards in the light of the change scenario and to meet the changes both domestically and internationally. Friends, we all know that Maharashtra is the second largest bar council in our country after Uttar Pradesh. In fact, our country is the second largest bar council after US. I am told that we have, as of today, approximately 1,75,000 lawyers on our own. And every year, about 9 to 10,000 lawyers are joining every year. In the current scenario, the nature of work, the nature of litigation, the style of working has totally changed. Now, the mode of communication is inclusive of technology like mobile, WhatsApp, email, e-filing, video conferencing. And during this pandemic time, we have realized the importance of technology. When the entire country was almost shut down, the judiciary and our legal system continued to work, even during peak pandemic, through use of technological platform, such as hearing through video conferencing, filing through electronic medium, etc. Large number of matters were heard and disposed of, reliefs were granted, and we have seen that both the Chief Justice who are present here have done commendable job on the judicial and administrative side in imparting justice to the common man while protecting the safety of the lawyers and so that they are not exposed to pandemic for the purpose of practicing their vocation. It's a common experience of all of us that what we study in the college, what we read in the books, and what we find in actual practice is totally different. Often we have seen that the student who may not fare very well in his academic career, who may not score good marks in his law degree, but yet he becomes a very good lawyer, because according to me, what is important apart from the knowledge of law is the court craft, or what we call it as a court craft. The Bar Council has promoted many schemes for training of junior lawyers because it was found that the junior lawyers who do not come from the family background of the lawyers, judges, or from the members of legal fraternity, they used to find very difficult to get seniors. Even today, we have seen in this profession that unless you have some connection, in the sense either you are from the members of family members of legal fraternity or have some good reference, you don't get good chambers. And as I mentioned, there are 9,000 lawyers every year enrolled in Maharashtra. Now, this is how the Bar Council helps to such lawyers in the training program, and especially in the initial days of practice. And as I rightly mentioned by my friend Jai Bhavesa, that even if you get good seniors, the seniors are so busy in his own work that he hardly gets time to train his juniors, especially during this pandemic, it was very difficult. So therefore, these type of programs, lecture series, especially the basic legal education program, the continuous legal education program with the Bar Council has been conducting since last 15 years. This has been very helpful and has been successful and has been helping the lawyers to develop their advocacy. I recollect somewhere in the year 2011 and 12, when I was the chairman of the Bar Council of Maharashtra and Goa, we had a state level conference. Justice Mohit Shah, the then Chief Justice of Bombay High Court, was addressing us. And we were all shocked to hear that there was a vacancy for a judicial post. I think it was a civil judge junior division or first class magistrate, where there were about 140 vacancies. Large number of applications were received, and only 50 could be appointed and 90 posts were kept vacant because no competent lawyers were found who could be appointed as judges. In the same function, Justice Abhay Oak was present. And then he suggested that why not the Bar Council of Maharashtra and Goa should start a training program for the lawyers who are aspiring or who are interested in becoming judicial officers. And since then, the Bar Council has started the program, has been for all of us that in the recent appointment of judicial officers, most of the candidates who have attended the judicial training program, they have been selected. This shows the success of the program organized by the Bar Council of Maharashtra and Goa, and I must really congratulate the Bar Council of Maharashtra and Goa for taking this effort. We all know, friends, that ultimately we say that, and rightly say, that bar is the mother of the bench. Unless you have competent lawyers, you cannot have competent judges. We are all aware that there is a heavy burden of litigation in all the courts, and all the courts are flooded with matters. It's practically impossible for a judge to decide all matters on his or her daily board, and due to pendency, there is a delay in disposal, heavy cost, uncertainty, and the expectation of common man doesn't get fulfilled. Therefore, apart from increasing the strength of the judges, it is equally important that the same are filled with competent people. We all know that unless, as I've already mentioned, that we require therefore a good training program, which is now undertaken by the Bar Council. As we have seen that neither the legal education nor the legal system till now encouraged the law student or a junior lawyers to become judges. This effort has been undertaken for the first time by the Bar Council of Maharashtra and Goa, and this has been appreciated all throughout the country. My Shri Manan Mishra, the Bar Council Chairman, is here. Bar Council Chairman of India is here, and he will agree that this is the first program which was started by the Bar Council of Maharashtra and Goa, and it is being continued since last several years. We are happy to note that apart from the basic legal education program, the judicial service as a career, the Bar Council is also starting a new training program for prosecutorship as a career. For imparting justice, the office of the government pleader, the public prosecutor, both the central and the state, plays a very important role. There are a large number of litigations where state and union are party. Competent prosecutors and government pleader would certainly assist the court in administration of justice. I'm sure that this 8 days program, which is 4 days physical and 4 days virtual, where experts from the bar and bench will share the knowledge and experience, will be helpful to the lawyers who are joining the profession. And we are really glad to know that about 12,000 lawyers are the participant in this function, in this training program, and this itself shows the success of the program. I look forward to all the participants continuing to carry on the legacy of legal profession and being part of the system of ensuring dispensation of justice to all. My best wishes to all the participants of this program and for all their future endeavor. Thank you. Thank you for the organizers for inviting me and giving me this opportunity.
Thank you very much, sir, for your encouraging words. I now request Chairman of Bar Council of India, Honorable Shri Manan Kumar Mishra, sir, to address the gathering.
Honorable Mr. Justice Abhay Oka, the Honorable Chief Justice of Karnataka High Court, Honorable Mr. Justice Deepankar Datta, the special guest, the Chief Justice of Bombay High Court, my friend Mr. Anil C. Singh, Additional Solicitor General of India, Mr. Asutosh Kumbhakoni, the Advocate General Maharashtra, Mr. Devidas Pangam, the Advocate General Goa, Mr. Gordipe, Chairman Bar Council of Maharashtra and Goa, Mr. Satish Deshmukh, the Vice Chairman Bar Council of India, Mr. James D. Jayabhabe, the Senior Member, former Chairman Bar Council of Maharashtra and Goa, Mr. Ashish P. Deshmukh, the Senior Member, former Chairman of Bar Council of Maharashtra and Goa, and Chairman of this program, Mr. Advocate Ajit Pathak, Mr. Sangam Desai, all the honorable dignitaries on the dais, off the dais, and the learned participants. A very good afternoon to all. Friends, BCI has always been appreciating the training programs organized by the Bar Council of Maharashtra and Goa. This basic legal education program is the new initiative of the State Bar Council. This is for providing compulsory 8 days training for the newly enrolled advocates. Legal profession is the process of continuous learning as per the need of the hour of the changing society. The law changes daily. The Bar Council of Maharashtra and Goa, I must tell you, is the pioneer Bar Council, and this step taken by the State Bar Council would be again appreciated by all. My friend Anil Singh, he said that the earlier program with regard to the training for judicial services that were appreciated not by only the Bar Council of India, rather by the whole country. He's perfectly right in saying that these novel steps of the Bar Council of Maharashtra and Goa, this is appreciated and praised by throughout the country. The different topics you have chosen, the schemes you have formulated for this program are all going to prove the boon for the young lawyers. And Bar Council of India assures the State Bar Council of Maharashtra and Goa to extend all sorts of cooperation. And the Bar Council of Maharashtra and Goa shall be given the responsibility under the guidance of Honorable the Chief Guest today, Justice Oka, and the special guest today, Justice Dipankar Datto, to make such programs popular throughout the nation. Now, I won't waste your valuable time. We have to listen to our honorable chief guest and honorable special guest. Therefore, the time is very short. I wish this program a grand success. I shall always be happy to be a part of this program. Wherever you need any sort of assistance from the Bar Council of India or from Manan Mishra, we are here to serve the young lawyers of the country. Thanks to the organizers. Thanks to all. Jai Hind, Jai Bharat.
Thank you very much, sir, for your encouraging words. Now I request our member, Shri Sangram Desai, sir, to introduce our special guest for today, Honorable Chief Justice of Bombay High Court, Shri Dipankar Datta, sir. Prior to that, just announcement to those who are watching on YouTube, please do not post your enrollment number. It is not required.
With your permission, it's an honor to introduce Honorable Justice Dipankar Datta. Born on February 9th, 1965, son of late Salil Kumar Datta, a former judge of the High Court at Calcutta, and brother-in-law of Justice Amitava Roy, former judge of the Supreme Court. He was awarded LLB degree by the University of Calcutta, the first batch of 5 years law course, in 1989. Enrolled as an advocate on November 16, 1989. He practiced mainly in the High Court of Calcutta as well as the Supreme Court of India and the other high courts in constitutional and civil matters. He was the junior standing counsel for the state of West Bengal from May 16, 2002 to January 16, 2004. Was also a counsel for the Union of India. Appeared for a number of educational authorities and institutions, including the University of Calcutta, West Bengal School Service Commission, and the West Bengal Board of Secondary Education. Was a guest lecturer on the constitutional law of India in the University College of Calcutta from 1996 to 2000. He was elevated to the bench of High Court at Calcutta as a permanent judge on June 2nd, 2006, and was further elevated as the Chief Justice of Bombay on April 28, 2020, and has been successfully leading all us in this difficult situation of pandemic COVID-19. I introduce to you all the Honorable Justice Deepankar Datta. Thank you so much.
I request Lordship Chief Justice Shri Deepankar Datta to address the gathering.
My elder brother, Honorable Abhay Ok, Chief Justice of the Karnataka High Court, Honorable Judges of the Bombay High Court, if they have joined online, Mr. Anil Singh, Additional Solicitor General of India, Mr. Ashutosh Kumbhakoni, Advocate General for the State of Maharashtra, Mr. Devidas Pangam, Advocate General for the State of Goa, Mr. Manan Kumar Mishra, Chairman, Bar Council of India, Mr. Anil Govardipe, Chairman, Bar Council of Maharashtra and Goa, Mr. Sudeep Pasbola, Vice Chairman, Bar Council of Maharashtra and Goa, Mr. Praveen Ranpise, Secretary, Bar Council of Maharashtra and Goa, other office bearers of the Bar Council of Maharashtra and Goa, esteemed members of the Bar, distinguished guests, and ladies and gentlemen who have joined online. Good afternoon once and all. At the outset, while paying obeisance to the memory of late B.E. Awad, let me congratulate the Bar Council of Maharashtra and Goa for organizing this function through the virtual platform to inaugurate the basic legal education program for the newly enrolled members of the Bar and publication of booklet titled Judicial Service as a Career and Prosecutorship as a Career. Having been conferred the honor of gracing this occasion as special guest, I consider it to be a moment of pride and privilege for me to share screen space with Chief Justice Oak and the other dignitaries. My previous speakers have given you an overview of what the legal profession requires of you and how you should make a start and thereafter continue. As Mr. Kumbhakoni has rightly observed, sky is the limit and one should not run after money from day one. The topic on which I have been invited to address the gathering as well as the 12,000 odd newly enrolled members of the Bar is vision for working in judicial system in pandemic situation. Vision for working in judicial system is a wide subject, but since the scope of the address is limited by pandemic situation, I would take care not to cross the limit set by the organizers. Pandemic or no pandemic, the first and foremost thing that an advocate who is a fresher in the legal profession must remember is that you need to maintain very good health if you aspire to continue for long as a legal practitioner. Next comes another important aspect. I am sure every senior member who has been successful in the profession would agree that none has tasted success without struggle. Struggle for what? It's a struggle for existence, a struggle for finding a foothold in the profession, a struggle to impress the senior as well as others who come to court looking for the raw talent to brief them, all culminating in a struggle for survival. That during prevailing circumstances where the pandemic has brought about untold misery in our lives. The need to maintain healthy habits and adhering to protective protocols cannot be overemphasized. There is a saying, an ounce of protection is worth a pound of cure. Although the newly enrolled members have recently acquired eligibility for vaccination, but might not have been fortunate to receive the first shot of vaccine, my advice is that you must try to have the vaccine at the earliest whenever it is available. And do not forget to wear the mask at all times except when you are alone. I urge you to keep these basics in mind. Now, turning to the pandemic, one cannot be oblivious of its negative impact on society. We have experienced our near and dear ones leaving us forever, many individuals losing their jobs, the majority of the labor class being left without employment, business prospects shrinking, leading to winding up of business, advocates surrendering their license to practice and taking to selling vegetables or even driving auto rickshaws to eke out a living, those who had purchased cars or purchased spaces for offices with financial assistance from the banks, defaulting in paying installments, people either surviving half-fed or even being on the brink of starvation, and what not. The list is endless. The more one thinks about such misery, the more he plunges into the depths of despair. Grappling with the once-in-a-century public health emergency, the central government declared one of the most stringent measures to combat it, the lockdown, in March 2020. We had never seen this before. The constitutional courts were called upon to evolve appropriate responses. All across the country, the constitutional courts, as a proportionate response, quickly transposed all courtroom hearings from a physical setting to a virtual one in April 2020. Order dated 6 April 2020, passed by the Supreme Court, officially recognized video conferencing as a method of ensuring the continuity of administration of justice in the times of the pandemic. The high courts were given the freedom to formulate ad hoc regulations to give full effect to the same. As courts embraced video conferencing to tackle the challenges brought about by the pandemic, a new facet of inequality arose. Borrowing the words of the Supreme Court, such inequality is in the form of digital divide. Absence of a stable internet connection and ICT resources in India's districts ensure that not all stakeholders of the justice delivery system claim access to courts through video conferencing. As multiple states imposed travel restrictions, thereby limiting the right to travel freely throughout the territory of India, all the stakeholders were faced with a new system, which was dubbed expensive and, above all, inaccessible. With infrastructural, policy, and technological issues at the core of this grievance, strong responses were required to ensure a last-mile delivery in the access of justice by the courts to the citizenry as the pandemic raged. More than a year has passed since then. During this time, multiple high courts have experimented with a hybrid approach of hearings, encompassing both physical and virtual hearings. Bombay High Court was one of the first high courts, if not the first, to return to physical hearings from 1st September 2020. Between 1st December 2020 and 7th April 2021, all the benches, barring a very few, resumed physical hearings. District courts too opened up. By and large, things were moving in the right direction. Unfortunately, after successfully overcoming the first wave, we let our guards down. The result was the second wave, which has hit us harder than the first wave in the sense that it has been more lethal in its impact. The ferocity of the second wave witnessed in the country from mid-April onwards has re-emphasized that virtual hearings may not be on the way out. Although I do not see virtual hearings as a substitute for physical hearings, the former is here to stay to complement physical hearings well into the future. At the High Court, we are all conscious of the concerns that have been and are being raised by a section of the members of the bar and the litigants appearing in person, albeit rightly, about the inconveniences and difficulties being faced by them while they seek to participate in judicial proceedings through video conferencing. Poor connectivity, lack of requisite tools to connect, and inferior audio-video quality are the common problems that have often hindered the concept of access to justice, which every authority involved in the justice delivery system under the Constitution so zealously attempts to secure for all. The vision of the E-Committee of the Supreme Court of India is to establish a judicial system which is inclusive, efficient, and equitable, and promoting and enabling technology-driven courts is one of the steps in contemplation to make justice accessible and affordable for all persons. The E-Committee has been working hand in hand with other high courts to ensure that the virtual court system is effective and provides equitable access to all users, inspiring confidence amongst them to fulfill the guarantee of access to justice. Having regard to the statistics available in the public domain, one can see the number of cases heard by courts through video conferencing from April 2020 till May 2021 using the digital infrastructure, and it is well acknowledged that globally, India has been at the forefront in conducting cases through video conferencing during the pandemic. Considering the present situation, let me tell you all that all E-Committees of the High Courts have been cooperating with the E-Committee of the Supreme Court on making available a robust, efficient, and user-friendly video conferencing solution to users for effective hearing of court proceedings. I may refrain from disclosing further details now, but would assure you that the digital divide may not last too long if the infrastructural, policy, and technological issues are resolved soon. So what is my message to the young advocates? My message is, do not look back and repeat. Look forward and prepare for the future. We practiced during times when internet was unknown. There was no display board indicating the item number being considered by the court. We had to run from court to court to ascertain the same. Many a time, matters were dismissed for default for non-appearance, thereby incurring the wrath of our seniors. You're all privileged in the sense that you would start practice in the digital era, where you would have to make less physical movement and be enabled to focus on the merit of your case. You need to equip yourself with the gadgets that are necessary to join online. You need to adapt to the changing times. Earlier, in our times, we had to spend thousands, not only on books and journals, but another few thousands to locate adequate office space and accommodate the books and journals in wooden or iron shelves in our offices. The digital era has brought books and journals to you in a pen drive. You don't need to look for space at least. Yes, I do agree that the gadgets are costly, but you must consider these as your assets in your pursuit to secure justice for your client. Do not be like a bad workman who brings his tools. Remember, a journey of 1,000 miles begins with a small step. Also remember the saying, as you sow, so shall you reap. I am confident that the books released today would be of immense help to all the junior lawyers, irrespective of when they have enrolled. I am equally certain that the speech to be delivered by Chief Justice Oak would be of immense help to all of you in discharging your duties in the manner the noble profession requires you to do. I would expect all of you to equip yourselves with appropriate court manners, court craft, acquire erudition, and master the art of advocacy to assist us administer justice in accordance with constitutional norms and ethos. Court etiquette, while appearing in virtual hearings, is another significant aspect which you all ought to bear in mind. Since Brother Chief Justice Oak would be speaking on professional etiquette, I may not elaborate. Insofar as the role of the Bar Council is concerned, their present effort is commendable, to say the least. I sincerely believe that in the days to come, more such educational programs shall be organized to help junior members to evolve as worthy members of the profession and equip the members of the bar across all age groups to assist us in the best possible manner to reach out to the people at large. Since I have not been able to visit the districts because of restrictions that are in place, and given the size of the state, it has not been possible for me to the grassroots level. Consequently, the difficulties and inconveniences faced by the members of the bar there could not be assessed by me. I would invite suggestions and feedback from you to bring about improvements. I am sure that with your able cooperation, assistance, as well as guidance, would facilitate taking justice to the last mile. Before I conclude, I may inform all advocates who might have been eagerly waiting to know the next course of action that the High Court proposes to take with regard to hearings in courts all over the state from 14 June 2021. We have a meeting scheduled on 9 June 2021, which would be attended inter alia by the Health Secretary, Government of Maharashtra, the Municipal Commissioner, Mumbai Municipal Corporation, and the representatives of the Bar Council, as well as the representatives of the bar associations. Depending upon the input that we receive, the Administrative Judges Committee would decide on the next course of action. The steering wheel is in our hands. We know when to accelerate and when to press the brake. Trust us, the interest of all stakeholders will be given the care, consideration, and empathy they deserve in these exceptional facts and circumstances. Given the decline in positive cases in the state, let us all pray to the Almighty that physical hearings resume at the earliest, and if possible, by the 1st of July 2021. You all stay safe and blessed. Namaskar. Jai Hind.
Thank you, my lords, for your address. And I now request our member, Shri Sangram Desai, sir, to once again come on the dais and introduce our chief guest for today, Honorable Chief Justice of Karnataka High Court, Shri Abhay Ok, sir.
On 1960, did his BSc LLM in University of Bombay and enrolled as an advocate on 20th of June 1983. He started practicing in Thana District Court in the chambers of his father, Sri Srinivas Oka. In 1985-86, he joined the chambers of Sri V.P. Tipnis, a former judge of the Bombay High Court, and former Lokayukta. He appeared in several important matters and in public interest litigations. Elevated as additional judge of the Bombay High Court on August 29, 2003, and appointed as a permanent judge from 12th of November 2005. His Lordship took oath as the Chief Justice of High Court of Karnataka on 10th May 2019. He has delivered various landmark judgments, a very strong supporter of Bar Council of Maharashtra and Goa, and a source of inspiration to the Bar Council of Maharashtra and Goa and all the young lawyers. It's been a great honor to introduce you, Honorable Justice Abhay Srinivas Oka. Thank you.
I request Lordship to address the gathering.
Namaskar and good afternoon. Honorable Mr. Justice Dipankar Datta, the Chief Justice of Bombay High Court. As I am a product of Bombay High Court, I always address the Chief Justice of Bombay High Court as my Chief Justice. And therefore, my Chief Justice, Honorable Mr. Justice Dipankar Datta. Shri Mishra, Chairman of the Bar Council of India. Shri Anil Goa Dipe, Chairman of the Maharashtra and Goa Bar Council. Vice Chairman of the Bar Council. Other members of the Bar Council. Shri Ashutosh Kumbhakoni, Learned Advocate General of State of Maharashtra. Shri Devidas Pangam, Learned Advocate General of State of Goa. Shri Anil Singh, Learned Additional Solicitor General of India. Shri Ashish Deshmukh, Shri Jain Jaibhave, Shri Avinash Awad, other distinguished guests who are present here, and my dear young members of the bar. It is my honor and privilege to participate in this program arranged by the Bar Council of Maharashtra and Goa. For me, it's like homecoming. Bar Council of Maharashtra and Goa has undertaken several innovative programs. In fact, I can say that Maharashtra Bar Council is the leader in starting innovative programs. The first one, which all of us know, was continuous legal education program, which now exists for 15 years. Much is said about that program by earlier speakers, so I will not refer to that. The second and most important innovation done by the Bar Council of Maharashtra and Goa was a campaign for encouraging young lawyers to join judiciary. Now, the Bar Council is going to encourage young lawyers to take up assignment as law officers and prosecutors. Bar Council not only encourage young lawyers to take up the career in judiciary, regular coaching classes were conducted by Bar Council in various parts of the state for training young lawyers to appear for the examinations conducted by Maharashtra Public Service Commission and Bombay High Court. And now, this new innovation of basic legal education program, which has started last year. Mr. Jaibhave, few minutes back, said that they are not going to stop with basic legal education program, BLEP. But now they are going to come out with a practice manual, which is again a great and innovative idea. I am glad that Bar Council has realized that those who are going to join profession this year or maybe next year will find it very difficult to join chamber of any senior. Even if he joins chamber of senior, there will be very little opportunity for the senior to guide him, to groom him. And this is going to be a great step to have practice manual. I will appeal to the members of the Bar Council to have this manual in soft form also, which will be available to all young lawyers. Before I proceed further, I must say something about Advocate B.V. Award. I had occasion to meet him during the cliff functions of the Bar Council. Few years back, I was guardian judge of Pune district. Some senior lawyers requested me to have interaction with young lawyers who had recently joined the bar. I told the senior members of the bar that I will interact with lawyers who have completed not less than 2 years of practice. Pune is the biggest district court in the entire country, and therefore there are a large number of young lawyers who have not even completed 2 years of practice in the interaction. More than 50% of the lawyers who introduced themselves proudly stated that they were the students of B. Award sir. I must acknowledge enormous contribution made by Advocate B. Award in the field of legal education. Many things which I wanted to say have been said by the Advocate General of Maharashtra, Shri Kumbhakoni, and Shri Anil Singh. But before I proceed further, I endorse the view expressed by the Advocate General of Maharashtra, Shri Kumbhakoni, that every lawyer should ideally start his practice from trial and district courts. I must share with all of you that my experience of working in trial and district courts has enormously helped me to discharge my duties as a judge of the Bombay High Court, and even today as the Chief Justice of Karnataka High Court. Before I touch briefly the topic of professional ethics, I want to digress myself with the permission of my Chief Justice, Justice Dipankar Datta. Last year, after normalcy was restored, somewhere in October, November, a senior lawyer practicing in Karnataka High Court requested me to address informally a group of young advocates not confined to state of Karnataka, but also other states. He requested me to have a question and answer session with them, and therefore there was a small online program. Some of the young lawyers in Karnataka were physically present. A very young and bright lawyer from Maharashtra asked me a question. He claimed that he was a graduate of a very leading law school, and he had undergone 5 years full-time exhaustive course of legal education. He asked me a question, why this compulsory basic legal education is required after obtaining Sanat from the Bar Council. In fact, he said he had enrolled with the Maharashtra Bar Council, and he said that that was the query made by many young lawyers who have been enrolled with the Bar Council of Maharashtra and Goa from 2020. I answered the question briefly, but today, since more than 1,000 young lawyers are present, I want to emphasize what Bar Council has done. I want to say what is the importance of this basic legal education program. I must share with the young lawyers that during last few decades, the nature of the legal profession, and in fact, nature of the entire legal system has undergone enormous change. New laws have come. Number of additional courts and tribunals have been established. In fact, the number of courts and tribunals is ever increasing. In 70s and 80s, it was openly said that those students who could not secure admission to medical engineering and other professional courses used to come to law colleges and take admission to the law colleges. There may be an element of truth in that, But fortunately, from late 90s, the situation underwent a drastic change. There were drastic changes in the pattern of legal education. For years, it was understood that law can be only a part-time course. However, full-time 5-year courses were started by many law colleges. National law schools came into existence. As a result of that, from 1990 or from 2000, young talent started coming back to law degree courses. This brought about a major change in the legal education. Now, what is the necessity of this kind of legal education immediately after you come out of your law college? In the year 1982, the Law Commission, headed by Justice D.A. Desai, submitted 117th report, and that report emphasized need for education to the judges. That is the report which emphasized that there should be a National Judicial Academy and there should be academies at state level. For the first time, great deal of emphasis was laid on the fact that even our judges need education. Some of the younger lawyers may not be aware that in National Judicial Academy at Bhopal, even training courses are conducted for the judges of various high courts. And I must say that large number of judges of the High Court attend those training workshops. As the nature of legal education underwent change, the nature of legal profession underwent change, the nature of the legal system underwent change, even the members of the bar realized that they need education. And that is how idea of CLEP, Continuous Legal Education Program, was evolved and which became immensely successful. Mr. Mishra, addressing us from Delhi, also acknowledged the great success of CLEP. When I was a student of law, when I passed out after obtaining law degree in 1983, I had never heard about electronic evidence. Nobody dreamed in those days that there will be something known as electronic evidence. When I started practice, photocopy machines were recently introduced. Thereafter, fax came, and then there were floppies, CDs, pen drives on which data could be stored. Then came the Information Technology Act. Then came very important provisions like Section 65B, which attracts a lot of legal debate, not only in the courtrooms, but even outside. I remember about 4 to 5 years back, when I was guardian judge of the City Civil Court and the courts of Metropolitan Magistrates in Mumbai. In Central Hall of Mumbai High Court, we had arranged a full-day workshop on cyber law, and we had invited the entire team of Cyber Cell in Mumbai. Even some of my esteemed colleagues, the judges of the Bombay High Court, joined the said workshop. At the end of the day, I realized that it was a great learning experience for me. There was one head constable of Cyber Cell who delivered one of the most memorable addresses. He explained to us what is the difference between investigation of a traditional crime and investigation of cyber offense. Several things were revealed to us. One thing which I learned was that there can be 2 laptops having one IP address. I'll request the Bar Council that in the basic legal education program, please have some emphasis on electronic evidence and cyber laws. There were several occasions when I, as a lawyer, felt a need for such kind of continuous legal education programs. In 2002, there were large-scale amendments to the Code of Civil Procedure. At that time, it was the need of the hour to have such kind of training programs. I'll give a latest example. Under the Commercial Courts Act, the provisions of the CPC have been drastically amended so far as the same are applicable to commercial courts. The entire procedure of the trials before the commercial court has undergone change. For your information, I may share that Karnataka is the first state where we have a separate establishment of commercial courts, about 10 commercial courts in the city of Bengaluru, in a separate premises. I realized that the lawyers practicing before the commercial courts need training. They have not understood the purport of the drastic amendments brought about to Code of Civil Procedure by the Commercial Court Act. And lastly, about the importance of the training, I must tell the young lawyers, the successful lawyers of tomorrow, the successful judges of tomorrow, that please remember that you may be a merit holder in LLB degree course, but standing before a court of law and conducting case is a different ball game. You need completely different education for becoming successful in the traditional legal practice. In my college days, there used to be hardly one moot court or maximum 2 moot court competitions in a year. But now there are several moot court competitions. There are trial moot court competitions. There are judgment writing competitions. I welcome this step. But if some of the judges of the Bombay High Court had joined today's function, they will agree with me that many young law graduates who come from leading law colleges and law schools, when they start appearing before the court, they do not understand the difference between moot court and the real court. So on many occasions, I had to tell the young lawyers that, young friend, your moot court days are over. Now you are in real court. This is one more reason why this kind of a training is necessary. And therefore, I again compliment the Bar Council of Maharashtra for taking this innovative step. Now I come to the conduct of the members of the bar. In no law college, you will get the training how to behave in the court. Nobody will tell you what is court craft. Nobody can teach you court craft. I must tell the young members of the bar that I love this young generation of lawyers. They are very intelligent. They are very ambitious because they have undergone a quality legal education. But sometimes I find that there is reluctance on the part of the young lawyers to do something basic. When I started practicing in district court, my first guru, my first trainer was clerk working in my father's office. For first few days, he taught me how to file a suit, how to file an appeal. He took me from one department of the court to another department. Then I realized how summonses and notices are prepared, how they are served. When I joined High Court, my senior instructed me that first few days I should take tour of High Court offices with his filing clerk. I must say that these tours of offices of the district court and High Court were great learning experiences for me. In those days, the function of the junior advocates was to go through the record of the proceedings and prepare notes. Now, these are few things which present young generation of lawyers avoid doing. I must impress upon them that this is something which is very important. Another area which Mr. Kumbhakoni has spoken about, there is no substitute for hard work. I carefully went through this book, which is released at my hands on basic legal education program. I saw articles written by some of the eminent members of the bar. I can share with you that I have seen some of them practicing. Dr. Milind Sathe, Advocate Ashutosh Kumbhakoni, Advocate Rajiv Patil, Advocate Gajanan Chauhan. I have seen how hard they have worked, how much time they have given to the profession. And they were not successful overnight. Only after doing great deal of hard work, only after doing slogging, that today they are successful, and therefore you find that they are leaders of the bar and their articles are published not only in this book, but in different parts. Another important aspect which Chief Justice Dipankar Datta touched, I want to little elaborate on that. That is requirement of having technical knowledge to operate various gadgets. As Chief Justice Dipankar Datta said, in many high courts, including Mumbai and Karnataka, we restored virtual normalcy from September. In fact, in Karnataka, all the courts continued to work normally till 2nd or 3rd week of April. Then came the second wave. I must also tell you that from September to April in High Court, all courts functioned in hybrid mode. And I could see about 25 to 30% of lawyers joining hearing by video conferencing. Now everybody is talking about the third wave. Therefore, it is important that young members of the bar must acquire necessary technical knowledge to use all these tools. Some of you must be aware that almost all high courts have framed video conferencing rules. There are highly technical issues concerning implementation of the video conferencing rules. It is very necessary for the young lawyers to study the video conferencing rules. There are various concepts as persons sitting at remote point. The rules lay down in detail how a document can be shown when evidence of a witness is being recorded through video conferencing hearing. Now, in future, even in some cases, there will be live streaming of the court proceedings. In fact, last week we have received draft live streaming rules framed by the E-Committee of the Supreme Court. As and when live streaming becomes reality, it is going to completely change the nature of the legal profession. Now, something about VC hearing. I want to emphasize for the benefit of the young members of the bar, something which we as judges experience while we have this video conferencing hearing. When a lawyer addresses the court through video conferencing hearing, he appears on the big screen. We as judges can see expressions on his face. We can notice how he is dressed, which is not normally possible in open court hearing. It is therefore important for the lawyers to ensure that, young lawyers especially, they are properly dressed. When they sit and address the court through video conferencing, they must have surroundings which are consistent with the dignity and decorum of the court. As a lawyer, as a young lawyer, I remember in Thane, there was a very eminent lawyer who was famous in the entire state. His name was Mr. R.D. Olekar. He gave a very important piece of advice to all juniors. He said, when you are standing before the court, either you are when you are arguing before the court, your eyes should focus only on the judge sitting on the dais. As far as possible, when you are arguing a case, you should not look on your left side or your right side, and to look behind you is the worst thing to happen. When you appear through video conferencing, this becomes very important. All eyes are focused on you, and therefore you must remember that your concentration should be at the judges. It is very important to learn the art of conducting video conferencing hearing. You have to mute yourself at proper time. There are incidents where we hear after the case is over, the lawyer commenting upon his opponent lawyer. Now, all these things are normally said in the corridors of the court. But we hear all these things in video hearing because you don't mute yourself. There are cases where after the hearing is over, lawyer forgets to mute, and we can hear his comments about the judge. To put it lightly, it is some kind of entertainment for us, but it's not good for the young members of the bar. They have to learn the tricks and art of appearing before the court through video conferencing. Now, time has come for the Bar Council even to train the lawyers for operating the gadgets. There are many lawyers who come from the rural background. They may not be conversant with operation of the modern gadgets, and therefore Bar Council will have to take up this task also. Now, coming to the conduct of the lawyers in the context of the professional ethics, it is my duty to remind the young members of the bar about the glorious traditions of the bar. It is only after you understand what are the glorious traditions of the bar that you realize the importance of your conduct as a lawyer. Perhaps many of you must have known this through history books, but I must say with emphasis that major role in freedom struggle against the British was played by the lawyers. And they were not the lawyers who were merely law graduates or lawyers for the namesake. They're all successful lawyers who compromised on their profession. Some of them gave up their practice and joined freedom struggle. We'll start from the father of the nation. He had established very good practice in South Africa. He gave up the practice. He came back to India, and rest is the history. I can give you several examples. For example, Vallabhbhai Patel had a roaring practice. He responded to the call made by the father of the nation, gave up the practice, and joined freedom struggle. Several examples I'll give you of eminent politicians who were eminent lawyers. Kanhaiyalal Munshi, who was the chief minister of Bombay state before the Bombay province before the independence. Bhulabhai Desai, a very eminent lawyer from the Bombay High Court who played a very important role in freedom struggle. Mr. B.G. Kher, who was perhaps the first chief minister of Bombay. One more interesting aspect I want to share with the young members of the bar. Till 70s and 80s, all leading education institutions and social organizations were controlled largely by the members of the bar. Almost, if you go into the history, you will find that many eminent lawyers headed very eminent education institutions. Now today, we find that the politicians have replaced the lawyers. The most important aspect which you as young lawyers will have to understand is that you enjoy a special status in our society. Your conduct, not only in the court, but outside the court, should be different than other citizens. You are more responsible than others. You are part of the justice delivery system. You are part of the system which enforces fundamental rights. You are part of that system which ensures that constitutional philosophy is abided by. Therefore, whether you are in court, whether you are outside the court, a different conduct of higher standard is expected of you. It is the first essential part of the professional ethics. I'm not going to refer to and read those rules of professional ethics. All of you can go through that. They're available on the website. You can go through that. But you must understand this important facet of professional ethics, that you have to follow ethics not only when you are within the four walls of the courtroom, but also when you are outside the court complex. That is of great deal of importance. If you follow higher standards of behavior outside the court, that will enhance the prestige of the legal education, the prestige of the legal profession rather. As all of you know, there are various duties which are part of the professional ethics. There's a duty to the court, there's a duty to the client, there is a duty to the colleague. But I'm going to emphasize on your duty to the society at large. The first and foremost thing is duty to the court. As all of you know, that an advocate is first an officer of the court and thereafter is mouthpiece of his client. His first and foremost duty is to the court. It is not to the judge who is occupying the seat of the judge. It is to the court. It is to the institution of judiciary. It is to the cause which judiciary represents. Therefore, his first obligation, first duty is to the justice. He may be representing A client, he may be representing B client. Ultimately, it is his responsibility to ensure that a litigant who may not be his own client, who is entitled to justice, gets the justice at the hands of the court. That is one of the most important duties of a member of the bar. As you are officer of the court, you should be fair to the court. You should be honest to the court. Fairness is one of the most important qualities. I can assure you that if you are a very fair lawyer, with the help of the hard work, you'll achieve a great success. I can share few secrets from the other side, because I have been a judge for nearly 18 years now. When we sit in the court as judges, we are very lonely. So we always look upon certain fair and honest lawyers to assist us. And therefore, young lawyers must have observed that a lawyer who is honest to the court, a lawyer is fair to the court, a lawyer is fair to the other side, he is always respected by the judges. You will earn the respect of the judges, you will earn the respect of your colleagues at the bar only if you follow fairness, if you are honest to the court. These are the two qualities which must be inculcated in lawyers at the budding stage. And therefore, my appeal to every member of the bar, young members of the bar, to remember these two qualities. By not pointing out the correct facts, by not pointing out the precedents which are against you, you may get temporary success, but it will remain temporary. For a long-term success, you need to be fair to the court. And remember that your first and foremost duty is to the cause of justice. You will find several rules about your duty to the client. But one of the most important duties of a lawyer is to tell the client, after studying his case, where he stands. If the client does not have good case, it is your responsibility to tell the client that he may not have good case, but you can always assure the client that you will do your best, and whatever few good points are available in his case, you will try to exploit those good points and convince the judge about the merits of the case. But you have to be very frank with your client. You have to inform your client your clear opinion about merits and demerits of the case. Third and most important is your duty to your colleague. As you have to be very fair to the court, you have to be fair to your colleague. Recent past, I have seen where a member of the bar appears before the High Court, and for that matter, any court, and requests for adjournment because the lawyer appearing in that case is unwell. I see some disturbing trend. Even such requests are opposed by some young members of the bar without realizing that they have to be fair to their colleague. They have to be sympathetic for to their colleague. There are a large number of instances which now we come across when one lawyer is making submissions, the other lawyer tries to disturb him. When I began practice in district court, I hardly saw such phenomenon. When I started practicing in Bombay High Court, very rarely I used to see that a lawyer who is arguing before the court was repeatedly interrupted. I fondly remember one of the greatest judges of the Bombay High Court, who eventually became the Chief Justice of Karnataka High Court. He followed a strict discipline. If a lawyer was arguing a case for admission before him, if the judge found that advocate for respondent utters even a single word to interfere with the submissions of the counsel for the petitioner appellant, his standard practice was to admit the appeal or to issue rule in the writ petition. He never tolerated interference by members of the bar when one lawyer is arguing. It is your foremost duty to your colleague in the profession that this kind of behavior is avoided. When you are arguing your case, you need a lot of concentration because you have to do justice to your client. If there are sudden interruptions and several interruptions, your concentration will be affected. So never follow that practice of interrupting your colleague. Even in trial courts now, this practice has started. When a lawyer is conducting examination chief or cross-examination, there are so many interruptions by the rival lawyer. All this has to stop. If your opponent has made a false statement, you always get a chance when your turn comes. You can always start your argument by pointing out what are the incorrect statements, what are the misleading statements made by your colleague. Therefore, you have to respect your professional brothers in the profession. Only if there is a mutual respect amongst the members of the bar, then the judges will be more effectively able to discharge their duties. The last and most important thing is your duty to the society. As I told you that whether it is a civil court, whether it's a district court, whether it's a session court or high court or Supreme Court, the ultimate object of the court is to ensure that the law of the land is enforced. It is only if law of the land is enforced, then the rights of the citizens, which are guaranteed not only by the Constitution, but under several laws, will remain intact. Only if the courts are able to enforce the laws properly, there will be something known as rule of law. For a healthy democratic society, rule of law is required. Only if there's a rule of law, then you can see healthy democratic society. Therefore, young lawyers, you must remember that you owe a duty to the society. Ultimately, all those who are concerned with the legal system, whether you are a lawyer, whether you are a judge, whether you are a member of the staff, it is your duty to ensure that the law is implemented, the provisions of the Constitution are implemented. Another aspect of your duty to the society is to help poor and needy litigants. I must say this for the benefit of the members of the bar, that when we assemble for such functions where judges are there, lawyers are there, we always talk about docket explosion. But according to me, the real serious issue is docket exclusion. Still, there are many poor people, many people belonging to marginalized sections of the society. They are not able to approach the court of law for establishing their rights. Sometimes they suffer injustice silently. Now, these are the categories of citizens which need help from the members of the bar. It is only if members of the bar help such litigants, their cases will come before the court. Therefore, as you grow in profession of law, as you start succeeding in profession of law, please remember to do legal aid work. You may do legal aid work. One form of doing legal aid work is to appear for such poor people in civil and criminal courts. The other form of legal aid work is to participate in various activities of the legal service authority at state and district level. They conduct legal awareness camps. They conduct several activities. Therefore, please remember that when you succeed in the profession of law, when you start earning handsomely, please do not forget your responsibility to the society. Several young lawyers can act as paralegal volunteers. They can work as volunteers for legal service authority. What young lawyers can do and young law students can do, I'll share only one example and then proceed to close. When I was executive chairperson of the Maharashtra Legal Service Authority, there was a function of mediation conference was there in Pune. I received a phone call from an old woman. She told me that her one arm has been amputated and she can move only by wheelchair. Those were the days when banks had declared that unless the Aadhaar card is linked with the bank accounts, the person will not be permitted to operate the account. With some help, she went to a center where Aadhaar cards were issued. She was told that she does not have one arm and therefore the fingerprints cannot be taken, and therefore she was turned back. So she requested for my help. I don't know from where she got my cell phone number. I immediately got in touch with the Secretary of the District Legal Service Authority. He in turn contacted some young law students, and I'm told one or two young lawyers, who took up the calls. They approached UDI, and within few days, the entire team of UDI visited the residence of that lady. And thereafter, within 3 days, the lady could get the Aadhaar card. She acknowledged the effort of the Legal Services Authority and young law students and young lawyers for helping her to get Aadhaar card. So there are several things which you can do for the society when you become a successful lawyer. And therefore, my appeal to you is that I'm sure that most of you will be successful because Chief Justice Chagla had said that nothing succeeds like a success in legal profession. And therefore, please remember your obligation to the society. These are my few thoughts which I wanted to share about the professional ethics. Before I close, I want to make one more appeal to the young members of the bar. I do not know about the state of Maharashtra, but in Karnataka, when we requested the Advocate General and the state, the judges were categorized into frontline workers for vaccination. All the members of the bar were put in priority group, which is third in order. The first are, of course, healthcare workers, second frontline workers, and third is the priority group for the purpose of vaccination. I'm sure that in Maharashtra also, the government must be actively helping the judicial officers, the members of the staff, and the members of the bar to undergo vaccination. Chief Justice of Bombay High Court appeal to everybody. I must reiterate that vaccination is the only possible step to prevent spread of COVID-19 and to prevent that possible third wave of COVID-19. What is important is different. Now almost all states have recognized the judges and the lawyers fall in some kind of a frontline workers, and therefore that has enhanced our responsibility. We must truly work like frontline workers. Just look at the other frontline workers. Look at the police. Look at the revenue officers. Look at those who are working in hospitals, medical and paramedical staff. Look at some of the civil servants. They are all on the field. They are doing their duty. Therefore, after taking all precautions like wearing double masks, washing your hands, it is responsibility of all the stakeholders of the institution of judiciary, namely the judges, lawyers, and members of the staff, to ensure that legal system works in best possible manner within the constraints imposed by the state governments under various standard operating procedures. We have to act like frontline workers. We have to ensure that the courts function to the best possible extent so that nobody is deprived of justice. This pandemic has led to multiplying the arrears in the court, and therefore there is a huge responsibility on all of us to do our best. Few days back I addressed a workshop by Bangalore Bar Association where I said that we who are the members of the judicial fraternity, judges and lawyers and members of the staff, we have to act like soldiers when we take on battle with this unseen enemy of coronavirus. And therefore, my appeal to the members of the young members of the bar is to cooperate with the judiciary and ensure that within the framework of standard operating procedures which are operating, maximum number of cases are conducted and justice is done to the common man. Before I close, I again compliment the Bar Council of Maharashtra and Goa for their all excellent innovations, their great initiatives. I'll request Mr. Mishra, who is present from Delhi, to ensure that the best practices adopted by the Maharashtra Bar Council are shared with other bar councils so that each bar council in every state can innovate and start their own programs following the framework set up by the Maharashtra Bar Council. I thank everyone who is associated with today's function for giving me this great opportunity to interact with the young lawyers After a long time, I could see very familiar faces of the senior lawyers, members of the bar, the office bearers of the Bar Council. And therefore, I said in the beginning, I felt like it was my homecoming. I also thank the Chief Justice of Bombay High Court, my own Chief Justice, Justice Dipankar Datta, for his presence. Thank you very much. And I wish a great success to young members of the bar who are present in large numbers, either on Zoom or through the medium of YouTube. Thank you very much and all the best to all of you. Namaste and Jai Hind.
Thank you very much, my lords, for your encouraging words. I am sure the new members of the bar will be highly benefited from the advice given by my lords, and they will try to follow the path which is shown by my lords. Now I request Vice Chairman of Bar Council of India, Shri Satish Deshmukh sir, to give vote of thanks.
मी करतो ना. करून टाक. मी नंतर करतो. Good afternoon, everybody. In this adverse situation of pandemic, all the dignitaries as well as participants have spared their valuable time for joining the inauguration of basic legal education program, for which I am very much thankful to all of you. Honorable Justice Abhay Oak, who inaugurated this training program today and also published the booklet of Blep. He is our mentor and also forced to drive the activity effectively since last 15 years. I thank him for inaugurating this function and request him for always observing our activities of training and guide us for any correction. Honorable Chief Justice of Bombay High Court, Justice Dipankar Datta, has also spared his valuable time to preside over this function. And by publishing the booklet of judicial service and public prosecutor as a career booklet, his efforts to see the safety of all judges, employees, advocates, and litigants in this adverse pandemic situation are really appreciate in state. I thank you, sir, for your presence today and also for your concern for Maharashtra judiciary. I thanks Honorable Senior Advocate Manan Kumar Misra, Chairman Bar Council of India, for virtually joining from Delhi. In fact, we have invited him at the 11th hour, but as the leader of the bar, he has always shown great support to the Bar Council of Maharashtra and Goa and accept our invitation, and I am thankful to you, sir. Honorable Advocate Anil Singh, Additional Solicitor General of India, Honorable Ashutosh Kumbhakuni, Advocate General of Maharashtra, Honorable Devidas Pengam, Advocate General of Goa, and part of the parcel of our institute. We are thankful to them for their presence. My colleague Bar Council, without any fear of pandemic, remain present in Mumbai and has designed this training program and also participate in the inauguration function. I am thankful to all of them. My colleague Apurva Kumar Sharma, Executive Chairman, also virtually joined. Thank you, Apurvaji. I am thankful to Honorable Avinash B. Award and the entire award family for the remaining present for the today's function. I am thankful to all the newly enrolled advocates who have joined this program with a big number, and I am sure that their participants in this training program will be hopefully hearted to make the program successfully. Now, 10 minutes break, and then after talk show, challenging of opportunities before legal profession in current scenario, 1.5 hours program after 10 minutes. Thank you. All the participants are requested to join after 10 minutes. Again, you are joined to program. Thank you very much. Jai Hind, Jai Maharashtra.
Thank you very much, Satish Deshmukh sir. All the participants are requested they do not disconnect. Although there's a 10 minutes break, but you can be online so that there is no again joining and disconnecting. So please be online. Do not disconnect from the meeting. We'll be back in 10 minutes. Insofar as the participants who are joining from YouTube live, please do not post your enrollment number. This is not a program where we are uh, attending, keeping track of attendance. It is an inauguration program. The further lecture program, everything will be communicated to you via email. So all the participants who are enrolled from 2020 till 2021, please check your emails so that Bar Council will communicate all the future programs through email. So this is our 5 minutes break. We'll resume after 5 minutes.
वीडियो बंद है बंद है ऐसे होगा कारण एक्सपर्ट तो उनको नहीं ये क्या उसका एक निकालना है हाँ ऑफिस में होगा लेके आना कमेटी के सामने
Yeah, yes. Uh, good afternoon, everybody. Uh, we are as we are facing a very turbulent times, and where the legal profession is undergoing a very difficult phase, and therefore it is necessary that as all the members of the bar, senior as well as junior, it is necessary to hear the persons who have spent n number of years in the profession to have a group discussion and group and we can find solutions. So in pursuance thereof, we are having a talk show where titled challenges and opportunities before legal profession in current scenario, where all the members of the Bar Council of Maharashtra as well as the dignitaries are going to have a discussion. So I request them to commence with the talk show.
We welcome all of you in this talk show. As this is the initiation of the training program for the new enrolled advocates, basic legal education program. And in connection to that training program, today we have organized this talk show. The subject of this talk show is challenges and opportunity before the legal profession in a current scenario. A current scenario means the current time, and also we can add a current pandemic situation, because it is something, an extraordinary situation which the profession is facing. So welcome all of you, all my young enrolled advocates, brothers and sisters. I welcome all the Bar Council members, Honorable Chairman Anil Gaurdite sir, Honorable Satish Deshmukh, Vice Chairman BCI, and all my colleague Bar Council members. We also have amongst us our former Chairman of the Bar Council and great law teacher, Advocate Sudhakar Awad sir. I also welcome you, sir, in this talk show. And let us see what types of challenges are there. Because it is always said that legal profession is a tough profession. Today the dignitaries have expressed their view. Advocate General said that there is no shortcut. The hard work is the only and only tool to become a successful. Many other important tips has been given by the Honorable dignitaries, Honorable Chief Justice of Bombay High Court and Karnataka High Court. So in light of that, we will also overlook our own experience by considering the dialogue with the new enrolled advocates as our family members, as our juniors. What are your views? What are the challenges which you have to face now? Particularly you young advocates has to face now. And along with that, really what opportunities you have in your hand. This will be the discussion of this talk show. This will be a discussion in this talk show. As your career starts with a legal education, and legal education, which we the law students took in the law colleges, is always said to be short for copying the practice. So it is always said that some sort of a bridging is required for the practice and the legal knowledge which we acquired in the law college. I take this opportunity to have a view from a very experienced law teacher, Dr. Sudhakar Awad sir. And I come to you, sir, with a question that the legal education, law education, and the practice in the field of law, what sort of a bridging is required, particularly in view of this new enrolled advocates who are with a law degree in their hand. now they are with sanad in their hand and they want to start their profession. How you will advise to connect this legal education with the application of this legal education in the practice, sir?
Thank you, sir. The question put to me for explanation is the legal education in the colleges and its application in the courts. In this behalf, rather I will say in this connection, rather I will say that, friends, the topic assigned to me is in respect of the legal education in the colleges and the practice in the courts. Friends, even the junior lawyers colleagues will find that there is an ocean change difference between the teachings in the colleges and practice in the courts. Rather, it is regrettable to say that ours is the only profession wherein a lawyer, after becoming advocate, he is not in a position to earn and conduct the trials immediately thereafter. Friends, if a person is admitted to the medical course, then during the medical course itself, he acquires such skills that even during medical course or even after completion of medical course, he immediately can treat a person, maybe with less excellence, but he is capable to do it. If there is a chartered accountant, then he acquires such a knowledge that during his internship itself, he is in a position to discharge the activities of a chartered accountant. Unfortunately, in our profession, this does not happen. Even though you put your 5 years for learning, acquiring skills and knowledge of law in the law colleges, but that falls short of enabling you to practice in the courts. Because our system is so based that there are no skills inculcated in you or imbibed in you in the law colleges, so that immediately after coming out of the law college, you can conduct the trials or the cases or serve the notices. This gap between the teaching in law colleges, acquiring legal skills in law colleges, and practice in the courts, this needs a bridge. And this bridge, according to me, has been achieved today by virtue of commencing such a scheme called as Blep in the name of late Bhaskara Award, sir. Therefore, by virtue of this Blep, this basic legal education program, what is wanting, what is necessary, what is deficit is those practical skills shall be inculcated in the upcoming lawyers, the new entrants like you people. I will request the entire Bar Council team present here that there shall be such lectures in this seminar or your course, so that there shall not be discussion as to any judgment or as to lengthy topic. I will suggest rather that there shall be small topics like how to serve a notice, like how to frame a suit, how to frame a specific performance suit, and likewise there shall be short aspects covered in the entire lecture, so that at the end of the lab training, say for instance in CPC, immediately after hearing your lecture, a young lawyer should be in a position to draft a notice, or at least to draft a plaint. Then only goods will be delivered. As it is said, consumer of justice of the scheme, this Blep scheme in the name of late award, sir, is to benefit the junior lawyers. According to me, if this happens, say for instance, regarding trial courts, criminal cases, friends, very recently I have heard a webinar by our member of the Bar Council, Mr. Sangram Desai. I have heard it for 2 hours, and you will find that from very beginning, from happening the offense till punishment, how small things they work. If you go to the police station, how that small thing works,
What are the registers at the police station? They have been explained in the webinar. Such webinars should be conducted in the Blep, like CPC, like other courses. But say for instance, my very favorite subject as to Hindu Succession Act, don't do it now here. They need it at a later course. But they need now as to trial aspects, as to how there shall be drafting, how there shall be pleading, and slowly the further aspects shall be inculcated as to how they shall go for argument. This issue, according to me, needs the bridging up between the colleges and the courts. Thank you.
Thank you very much. So while designing now the further subjects of the basic legal education, and also the new venture which Bar Council has taken, that is a practice manual for you all people, which we will be providing for this newly enrolled advocate. There, this angle which our sir has given, that the basic requirement which you will have to deal with the practice, they will be considered and they will be incorporated in the subject matter also, and also in a coming now the further practice manual also. Now in the morning, Kumbhakoni sir told that language is not material, but basically when we are practicing, suppose in the state of Maharashtra or in a Goa, local language is equally important. And therefore our Vice Chairman, Bar Council of India, today only suggested me that we should also conduct this program in Marathi, because it's a policy of the state that the language which is known to the litigant should be the language of the judiciary. So if a person, litigant, pakshakar, Marathit समजतो तो याच्याकरता मराठीत काम झालं पाहिजे. So this aspect of the language is also important, friends, for you. It is possible that some of you are convent educated and you do not have a much knowledge of Marathi. It is possible that some of you are from a rural area, you are well acquainted with Marathi, but you are afraid of English. Proper bridging of this language is necessary in profession. And for that purpose, we have with us a senior member, Advocate Gajanan Chavan, who also worked for a मराठीचा न्यायालयामधला वापर ही चळवळ चालवण्याकरता गजानन चव्हाणांनी एक फार मोठं काम केलं. मी त्यांना सांगेल की हा भाषेचा जो विषय आहे, या तरुण आलेल्या वकील मित्रांनी मराठी आणि इंग्रजी विशेषतः त्याकडे कसं बघावं आणि त्याचा दृष्टिकोन कसा स्वतःमध्ये डेव्हलप करावा, यावर तुम्ही मार्गदर्शन करावं. CRPC 273 प्रमाणे डिस्ट्रिक्ट कोर्ट लेवल पर्यंत न्यायालयाची भाषा ही मराठी आहे. हायकोर्टाची ऑथराइज लँग्वेज ही आज रोजी इंग्रजी आहे. ती ऑथराइज लँग्वेज कॉन्स्टिट्यूशन मध्ये राष्ट्रपतींच्या संमतीने मराठी करून घेता येईल. दॅट इज अ पार्ट. आता जी तरुण मंडळी या व्यवसायात नव्याने आलेत या वर्षी, गेल्या वर्षी, असा कॉम्प्लेक्स कॅरी करण्याची गरज नाही की मी मराठी भाषेतून शिकलोय आणि कोर्टामध्ये इंग्लिशमध्ये काही लोक बोलतायत, मी दबून जाईन, माझं इम्प्रेशन पडणार नाही. माझा अनुभव असा आहे गेल्या 40 वर्षाचा, मराठीमध्ये वकील बोलला तर ते न्यायाधीशाला चांगलं समजतं. गमतीने असं म्हटलं जातं की जो वकील मराठीमध्ये आर्ग्युमेंट करतोय त्याला सुद्धा कळतं आपण काय बोलतोय ते. यू कॅन एक्सप्लेन बेटर इन युअर ओन लँग्वेज. हायकोर्टामध्ये विषय वेगळा आहे. मी लोअर कोर्टामध्ये, तालुका लेवलला, डिस्ट्रिक्ट कोर्टामध्ये प्रॅक्टिस करणाऱ्या नवीन बिगिनर्सच्या संबंधात बोलतोय. सिमिलरली तुम्हाला इंग्रजी पण चांगलं आलं पाहिजे. आज चांगलं नसेल, मराठी भाषेतून तुमचं शिक्षण झालं असेल, बऱ्याच लोकांनी मराठीमध्ये लीगल एज्युकेशन सुद्धा घेतलेलं आहे. मराठीमध्ये लीगल लँग्वेज आली पाहिजे, कायदेशीर भाषा वापरता आली पाहिजे, कायदेशीर फ्रेज, कोटेशन्स वापरता आली पाहिजेत.
आणि इंग्रजी जर तुम्ही सफाईदार करू शकलात, तुम्ही इंग्रजी मराठीमध्ये, जिथे मराठीमध्ये खूप अडचण येते एखादा शब्द, एखादा विषय समजावून सांगायला, एखादा इश्यू समजावून सांगायला, त्याच्यामध्ये आपण इंग्रजीमध्ये कोर्टाला एक्सप्लेन करू शकतो. इट इज नॉट ओनली लँग्वेज, इट इज अ लीगल लँग्वेज दॅट यू शुड कमांड. आणि ही लीगल लँग्वेज जर आपण कमांड केली, अनुभवाने आत्मसात केली, कशा पद्धतीने सिनियर आर्ग्यू करतात, कशा पद्धतीने सिनियर कोर्टाला ऍड्रेस करतात, कोर्टाच्या क्वेरीवर कशा पद्धतीने उत्तर देतात, चांगल्या सिनियर्सना फॉलो करा. भाषेचा प्रश्न येणार नाही असं मला वाटतंय. आता इंग्रजी माध्यमातून आलेल्या किंवा शिक्षण घेतलेल्या इंटर्नसाठी त्यांना मराठी येतच नाही असं नाही, पण लोअर कोर्टामध्ये जर आपल्याला प्रॅक्टिस करायची असेल तर तुम्हाला आवश्यक ते मराठी आलं पाहिजे. मुंबई, ठाणे ही बहुभाषिक शहर आहेत, पुणे, नांदेड, नागपूर ही सुद्धा बहुभाषिक शहर आहेत. आज रोजी दावे मराठीमध्ये दाखल होत आहेत, पोलिसांच्या चार्जशीट मराठीमध्ये असतात. त्या समजावून घेण्यासाठी आपल्याला तितकंसं मराठी आलं पाहिजे. उद्या ज्युडिशियरीमध्ये जर आपल्याला जायचं असेल तर मराठी येणं अत्यावश्यक आहे. न्यायिक सेवेत जर जायचं असेल तर त्या दृष्टिकोनातून भाषा आत्मसात करून, लीगल लँग्वेज आत्मसात करून आपण चांगल्या प्रकारे प्रेझेंटेशन, आपलं जे व्यक्तीकरण आहे, व्यक्त होणं जे आहे कोर्टापुढे, चांगल्या प्रकारे करू शकतो. कुठली अडचण येणार नाही. आणि ग्रामीण भागातून येणाऱ्या विद्यार्थ्यांनी, ग्रामीण भागात शिकलेल्या मुलांनी, कुंभकोणी सरांचं इज ॲडव्होकेट जनरल ऑफ महाराष्ट्र ॲज ऑन नाव, संपूर्ण शिक्षण सोलापूरला मराठी भाषेत झालेलं आहे, माझं मराठी भाषेत झालेलं आहे. त्यामुळे हा कॉम्प्लेक्स येण्याची, काहीतरी न्यूनगंड आपल्या मनामध्ये बाळगण्याची आवश्यकता नाही. तुम्ही व्यक्त कसे होता हे महत्वाचं आहे, भाषेचा अडथळा येऊ नये. धन्यवाद.
मित्रांनो, यासाठी या आपल्या बेसिक लिगल एज्युकेशन कोर्समध्ये आम्ही नक्कीच काम करणार आहोत. चव्हाण साहेबांनी याविषयी अनेक वेळा व्याख्याने दिलेली आहेत आणि फौजदारी कायद्यामधले, क्रिमिनल लॉ मधले एक 100 शब्द आणि त्याला मराठी प्रतिशब्द, त्याचप्रमाणे दिवाणी कायद्यातले एक 100 शब्द आणि त्याचे मराठी प्रतिशब्द, याचे जर आपण अभ्यास केला आणि ते आत्मसात केलं तेवढे फक्त 100 शब्द. मला असं वाटतं की या दोन्ही भाषांमधला जो गॅप आहे किंवा त्याची जी एकमेकांना वाटणारी भीती आहे, ज्यांना मराठी येते त्यांना इंग्रजीची भीती, त्यांना इंग्रजी येते त्यांना मराठीची भीती, ती या कायद्याच्या कामकाजापुरती मला असं वाटतं आपण दूर करू शकतो. त्याच्यामुळे हा तुमच्या पुढच्या येणाऱ्या एखाद्या करिअर मधला एक महत्वाचा विषय आहे भाषा, आणि त्यावर आपण आता सगळ्यांनी काम केलं पाहिजे. ज्यांना मराठी येत नसेल त्यांनी वर्तमानपत्र लावले पाहिजे, मराठी वाचायला सुरुवात केली पाहिजे. ज्यांना इंग्रजीची भीती वाटते त्यांनी चांगलं जजमेंट, एक चांगलं छोटं जजमेंट बॉम्बे हायकोर्टाचं काढून ते मोठमोठ्यांनी स्वतः वाचायचं आणि आपल्या मोबाईलमध्ये रेकॉर्ड करून ऐकायचं. असे छोटे छोटे उपक्रम आम्ही आपल्यासमोर घेऊनच येऊ, पण तुम्ही देखील ते आत्मसात करावेत. एक अतिशय तुमच्या पिढीपुराचा एक मोठा आव्हान, चॅलेंज म्हणजे संख्या. आता असं म्हटलं जातं की इतक्या मोठ्या संख्येने वकील इथे येत आहेत. आज तुम्ही ऐकलं की आम्ही 12,000चा प्लॅटफॉर्म क्रिएट केलेला आहे. एका वर्षामध्ये साधारणतः 9,000 लोक वकील होतात. काय नक्की ही संख्या, कोणत्या संख्येने लोक येत आहेत, नक्की ती संख्या किती आहे, तुमच्या समोर काय ही आव्हानं आहेत संख्येची? मला असं वाटतं की मी आपले माजी अध्यक्ष आशिष देशमुखांना विनंती करतो की त्यांनी नक्की संख्या किती आहे, वकील वर्गामध्ये किती आपण भर टाकतोय, याबद्दल जरा आपलं सगळी माहिती या लोकांना सांगावी. हॅलो हॅलो
आतापर्यंत 2010च्या दृष्टिकोनातून जर आपण विचार केला, 2010च्या पूर्वीपर्यंत एक ऍव्हरेज मध्ये दरवर्षी 3,500 ते 4,000 ऍडव्होकेट्स हे दरवर्षी बार काउन्सिल मध्ये एनरोल त्या ठिकाणी व्हायचे नवीन ऍडव्होकेट्स. त्याच्यानंतर काही दिवसानंतर 2010च्या नंतर लॉ कॉलेजेसची संख्या वाढली, लॉ कॉलेजेसची संख्या वाढल्यानंतर त्याच्यातनं पास आउट होणारे स्टुडंट्स त्या ठिकाणी वाढलेत आणि लिगल प्रॅक्टिस कडे वळणारी जी काही मंडळी होती, जे कॉर्पोरेट कडे न जाता ज्यांना प्रॅक्टिसिंग ऍडव्होकेट म्हणून काम करायचं होतं, अशी जवळपास इन ऑल ऍव्हरेज 6 ते 6,500 ऍडव्होकेट्स दरवर्षी आपल्याकडे एनरोल होतात आणि गेल्या 2010 पासून आतापर्यंत जवळपास 18 ते 19 लाख 18 ते 19 हजार ऍडव्होकेट जे आहेत हे आपण त्या ठिकाणी एनरोल केलेले आहे 2018 पासून. 2020 साली आपलं पॅन्डेमिक जी सिच्युएशन निर्माण झाली आणि त्याच्यानंतर गव्हर्नमेंटने जी पासिंग क्रायटेरिया त्या ठिकाणी लावला कुठल्याही प्रकारची एक्झाम न घेता, त्याच्यामध्ये पासिंग पर्सेंटेज इतक्या मोठ्या प्रमाणामध्ये वाढलं गेलं की गेल्या वर्षी म्हणजे आता जो जानेवारी 2020 चा आम्ही जो फिगर घेतला तो जवळपास 9,000 ऍडव्होकेट्स हे त्या ठिकाणी एनरोल झालेले आहेत. जे अशा प्रकारे 1.5 ते 2.25 लाख ऍडव्होकेट्स आपल्या बार काउन्सिलच्या ऑन रेकॉर्ड त्या ठिकाणी एनरोल्ड ऍडव्होकेट्स म्हणून त्या ठिकाणी आहे. आणि हे करत असताना फार मोठ्या प्रमाणामध्ये एक समाजामध्ये मेसेज किंवा मीडियामध्ये अशा प्रकारचे चित्र की वकिलांची संख्या दिवसेंदिवस वाढत आहे, लॉ कॉलेजेसचं मशरूमिंग त्या ठिकाणी होत आहे, अनेक लॉ कॉलेजेस त्या ठिकाणी निघत असल्यामुळे वकिलांच्या संख्येमध्ये फार मोठ्या प्रमाणात भर पडते आहे आणि फार मोठी स्पर्धा त्या ठिकाणी निर्माण झालेली आहे. आम्ही जे चित्र बघतो त्याच्यामध्ये एनरोल झालेल्या ऍडव्होकेट्स पैकी जवळपास 51% ऍडव्होकेट्स हे त्या ठिकाणी रेग्युलर प्रॅक्टिस मध्ये येतात, काही सर्व्हिस मध्ये जातात, काही जॉब त्या ठिकाणी करतात. काही पर्टिक्युलरली स्त्रियांच्या बाबतीत बोलायचं झालं तर मुली एनरोल आमच्याकडे बार काउन्सिलला होतात, परंतु एकदा त्यांचं लग्न झालं आणि ते त्यांच्या सासरी गेल्यात की त्या ठिकाणी गेल्यानंतर त्यांच्या संसारामध्ये त्या होतात आणि मग प्रॅक्टिस कडे त्या तिकडे बघत सुद्धा नाहीत. नॉन प्रॅक्टिसिंग ऍडव्होकेट्सची संख्या ही त्या ठिकाणी एक चांगल्या मोठ्या प्रमाणामध्ये आहे. आणि हे करत असताना याच्यामध्ये आता चॅलेंजेस असे निर्माण झालेले आहेत. दिसायला आपल्याला मोठी संख्या दिसते, पण लोकसंख्येच्या प्रमाणामध्ये आपण जर बघितलं तर 10 लाखाला एक वकील अशा पद्धतीने त्या ठिकाणी आपण वकिलांची संख्या आपल्या महाराष्ट्रामध्ये आहे. आणि हे सगळं जर चित्र बघितलं तर मला असं वाटतं की या स्पर्धात्मक युगामध्ये वकिलांनी त्या ठिकाणी काम करत असताना एक सिस्टमिक स्वतःच्या प्रॅक्टिसची आखणी, आता जसं आपल्या इनॉग्रल फंक्शन मध्ये आदरणीय न्यायमूर्ती ओक साहेबांनी सांगितलं की आपण आपल्या व्यवसायाशी प्रामाणिक, इन्स्टंट रिलीफच्या मागे न लागता आपल्याला वकिली जर करायची असेल तर 5 वर्षाची त्या ठिकाणी आपल्याला वेटिंग पिरियड हा मानसिक तयारी करून आपण जर वकिलीमध्ये उतरलो तर निश्चितपणे आता ज्या प्रमाणामध्ये वकिलांची संख्या आपली एनरोल होते आहे याच्यामध्ये आणखी 1.5 पट जरी वाढ झाली तरी निश्चितपणे सामाजिक दृष्ट्या त्या ठिकाणचा विचार करता प्रत्येक वकिलालाच आपलं काम मिळू शकतं. प्रत्येक वकील हा प्रत्येक वेगवेगळ्या स्पेशलाइज फील्डमध्ये त्यांनी जर आपापलं क्षेत्र जर निवडलं की मी कुठल्या याच्यामध्ये स्ट्रॉंग आहे, माझं नॉलेज जे आहे मी कुठे देऊ शकतो, अशा पद्धतीने त्याचा वापर करू शकतो, हे जर एकदा त्याला इफेक्टिव्हली सगळ्या गोष्टी समाजासमोर त्याच्या क्लायंट समोर मांडता आल्या तर निश्चितपणे या वाढत्या वकिली लोकसंख्येच्या संदर्भामध्ये सुद्धा आपण अतिशय चांगला असं बॅलन्स त्या ठिकाणी ठेवू शकतो. आणि मला असं वाटतं की वकिलांच्या दृष्टिकोनातून त्यांनी त्यांची तयारी जर चांगली केली तर उद्या वेगवेगळ्या फील्ड्स मध्ये सुद्धा उद्या एकदा LLB पास झाल्यानंतर त्यांना मोठमोठ्या ऑपॉर्च्युनिटीज वेगवेगळ्या क्षेत्रामध्ये आहेत, त्याचा सुद्धा त्यांना त्या ठिकाणी लाभ घेता येतो.
त्याच्यामुळे संख्या खूप असली तरी त्यामध्ये तुम्हाला संधी देखील आहे. न्यायाधीशांच्या बद्दल आपण पुढे येणाऱ्या चर्चेमध्ये बघणारच आहोत. आज अनेक मोठ्या संख्येने न्यायाधीशांची गरज आहे, मोठ्या संख्येने प्रॉसिक्युटरची गरज आहे, वेगवेगळ्या ठिकाणी काम करणाऱ्या नवीन नवीन वकिलांची गरज आहे आणि नवीन नवीन दालनं ओळख उघडली जात आहेत. असं म्हटलं जातं वकिलीच्या व्यवसायामध्ये दर 5 वर्षानंतर एक नवीन कायदा येतो आणि तो नवीन कायदा नवीन दालन कामाचं घेऊन वकील वर्गासमोर उभा असतो. त्यामुळे आलेल्या पिढीने आपल्या येणाऱ्या काळामधला नवीन कायदा कोणता आहे ज्यामध्ये आपल्याला मोठं काम करता येईल, नवीन काम करता येईल, याकडे मला असं वाटतं की नवीन पिढीने लक्ष दिलं पाहिजे आणि ते आपण या निमित्तानं तुमच्या समोर मांडण्याचा नेहमीच या कार्यक्रमांमधून प्रयत्न करू. तुम्ही त्याच्यातनं आपली संधी शोधून मोठं होण्याचा प्रयत्न केला पाहिजे. आता खरा प्रश्न येतो त्यावेळेस पहिल्या कोणीतरी वकिलीच्या व्यवसायामध्ये जर असलं कुटुंबातलं, वडील आहेत, आजोबा आहेत, काका आहेत, तर त्या नवीन आलेल्या वकिलाला चांगल्या पद्धतीने उभं राहायला मदत होते. पण ज्याला फर्स्ट जनरेशन लॉयर म्हणतात, ज्याच्या कुटुंबामध्ये कोणीच वकील नाही, त्याला कोणीतरी सिनियर शोधावा लागतो, कुठेतरी धडपड करावी लागते. विशेषतः गाव सोडून ज्यावेळेस तो मोठ्या शहरांमध्ये कामाला जातो, वकील म्हणून कामाला जातो, तेव्हा दोन गोष्टी येतात. सिनियर मिळतो का, राहायची सोय होती का, ऑफिसला जागा मिळते का, या प्रॅक्टिकल अडचणी येतात. बार काउन्सिल मला असं वाटतं की या ठिकाणी देखील मोठ्या भावाची भूमिका पार पाडण्याचा प्रयत्न करत असते. यासाठी आम्ही काही प्रयत्न केलेले आहेत. बार काउन्सिलच्या जोडीला इंडियन ऍडव्होकेट मल्टीपर्पज सोसायटी सारख्या संस्था, ज्याचे चेअरमन आपल्या बरोबर आहेत, जे व्हाईस चेअरमन आहेत बार काउन्सिल ऑफ इंडियाचे, त्यांनी देखील केलेले आहेत. मुंबईत असे काही प्रयोग घडवलेले आहेत आणि ते आपल्यासमोर ठेवणं हे आमचं काम आहे की अशा प्रयत्नातून आपण येणाऱ्या अडचणींना देखील पार केलं पाहिजे. त्याच्यामुळे विशेषतः मोठ्या शहरांमध्ये या नवीन वकिलांच्यासाठी राहण्याची सोय, ऑफिसेसची सोय, या माध्यमातून आपल्याला काय प्रयत्न करता येतील, काय योजना सांगता येतील, यासाठी मी निमंत्रित करतो ऍडव्होकेट सतीश देशमुख यांना. त्यांनी आपल्याला थोडी त्याची माहिती द्यावी.
हॅलो, नमस्कार मित्र. आपण न्यूली इंटर झालेल्या असताना, हॅलो, न्यूली इंटर ज्यावेळेस होतो आपण कोणत्याही प्रोफेशन मध्ये, त्याच पद्धतीने आपण लॉयर प्रोफेशन मध्ये येत असताना आपण एका शहरातून दुसऱ्या शहरामध्ये प्रॅक्टिस साठी सिनियर शोधतो आणि सिनियर शोधत असताना आपल्याला राहण्याची पण व्यवस्था शोधावी लागत असते. आणि मग अशा परिस्थितीमध्ये आपल्याला राहण्याची सिनियर मिळाला आणि राहण्याची व्यवस्था होत नाही, त्या कारणामुळे आपण ती अपॉर्च्युनिटी आपल्यापासून वंचित राहते. ती वंचित राहू नये म्हणून आम्ही बार काउन्सिल महाराष्ट्र अँड गोवाच्या माध्यमातून आम्ही बार असोसिएशन डिस्ट्रिक्ट लेवलचे असतील, तालुका लेवलचे असतील, आम्ही त्यांच्यासोबत चर्चा करणार आहे. आणि आपल्यासारखे जे यंग लॉयर्स आहेत, जे उद्याचं भविष्य आहे महाराष्ट्राचं, देशाचं, त्याच्यापासून ते वंचित राहू नये म्हणून त्यांच्यासाठी आम्ही राहण्याची जशी मुंबईला व्यवस्था केली, आम्ही हॉटेल एम्पायर म्हणून व्हीटीच्या समोर एक हॉटेल आम्ही घेतलं 4 वर्षापूर्वी. आणि बाहेर आपल्या राज्यातून जे लोक सकाळी येतात ट्रेननी, कोणी फ्लाईटनी, कोणी बसनी, त्या लोकांना आम्ही 24 तासासाठी एक एम्पायर हॉटेल व्हीटीच्या समोर अवेलेबल करून दिलं. त्याचा रिझल्ट आम्हाला असा मिळाला मित्र की अनेक आमचे लॉयर लोक जे मुंबईचं काम मिळते म्हणून घेऊ लागले आणि मुंबईमध्ये येऊन काम करू लागले. आणि काम करत असताना आम्हाला त्याचा रिझल्ट असा मिळाला की एव्हरी डे 30 ते 40 लॉयर त्या हॉटेलमध्ये येऊन थांबत होते आणि काम करून दुसऱ्या दिवशी जात होते. म्हणजे एका दिवसाचं पेमेंट देऊन 2 दिवस राहायची व्यवस्था आम्ही त्यांना करून दिली होती. अशा पद्धतीचा आम्ही जिल्हा लेवलला त्या बार असोसिएशनची आम्ही टाईप करून तुमच्यासारखे जे ज्युनियर लोक आहेत, लॉयर आहेत, त्यांना राहण्याची व्यवस्था कशी होईल त्यासाठी आम्ही काम करणार आहे. दुसरं, एखादं ट्रायल, चांगलं ट्रायल इथं एखाद्या डिस्ट्रिक्ट लेवलला चालू आहे आणि ते ट्रायल ऐकायला जायचं आमच्या ज्युनियर बांधवांना, 2 दिवस राहायचे तर त्यांना 3 दिवस राहायचं, तर त्यासाठी सुद्धा आम्ही बार काउन्सिल महाराष्ट्र अँड गोवा आणि बार असोसिएशन कडून आम्ही टाईप करून तुम्हाला ती मदत देण्याचा प्रयत्न करणार आहोत. त्याच्यामुळं आपण प्रोफेशन मध्ये गोख साहेबांनी सांगितलं त्याप्रमाणे आपण बार आणि बेंच यांचा समन्वय कशा पद्धतीने साधला जातो याचा अभ्यास आपण करावा, ही त्या प्रसंगी मी
मित्रांनो. त्यामुळे आपल्याला व्यवसायामध्ये धाडसानं पुढे जायचंय. शक्यतो जितक्या पद्धतीने आपल्या पाठीशी उभं राहता येईल तेवढा प्रयत्न बार काउन्सिल करणार आहे. बार असोसिएशनला आपण विश्वासात घेऊया आणि याही उपर येणाऱ्या अडचणींना, या सगळ्या प्रॅक्टिकल अडचणींना मात करून कष्टानं ज्यावेळेस आपण पुढे जाऊ त्याच वेळेस या व्यवसायामध्ये आपल्याला खंबीरपणे पाय राहून उभं राहता येणार आहे. मित्रांनो, तरुण म्हटलं की थोडासा उत्साही असतो. आपण नवीन वकिली व्यवसायात जातो, कोर्टामध्ये आपण फिरू लागतो काळा कोट घालून. नवीन काळा कोट घातला की आपल्यालाही काहीतरी नवीन मिळवल्यासारखा एक जोश असतो. अशा वेळेस आपण कोर्टामध्ये कसं वागायचं यासाठी तुम्ही प्रोफेशनल इथिक्सच्या पुस्तकामध्ये एक शब्द नेहमीच ऐकत आलेला आहात, तो म्हणजे मेंटेन्ड डेकोरम. व्हॉट इज दिस? मेंटेनिंग डेकोरम मीन्स व्हॉट? कोर्टासमोर वागणं असो, कोर्टाच्या बाहेर आवारामध्ये फिरणं असो, त्याचबरोबर 4 मित्रांनी एकत्र येणं असो, कुठल्या तरी कारणाकरता वादाकरता कोर्टामध्ये काहीतरी होणाऱ्या अडचणींच्या बद्दल निवारा करण्याचा प्रयत्न असो, त्यातून कधीतरी वाद होतात, मग आपण कधीतरी संपापर्यंत येतो. या सगळ्या गोष्टी या कोर्टाच्या आवारामध्ये घडत असतात. कायद्याने आपल्याला असं अपेक्षित असतं की द लॉयर मस्ट मेंटेन द डेकोरम ऑफ द कोर्ट. हे नक्की काय आहे? मला असं वाटतं की नवीन वकील म्हणून आपण समजून घेणं गरजेचं आहे. मी माझ्या मित्राला घेऊन काळा कोट अंगावर असताना त्याचा हात माझ्या खांद्यावर ठेवून फिरू शकतो का? मी काळा कोट घालून समोरच्या कुठल्या तरी पानटपरीवर पान खाऊ शकतो का? अनेक गोष्टी असतात. शेवटी यू आर अ लॉ ऑफिसर. या गोष्टीनं आमचे सदस्य सन्माननीय डॉक्टर उदय वारंजीकरांकडे येतो आणि त्यांना विचारतो की हे मेंटेनिंग द डेकोरम ऑफ द बार अँड कोर्ट याबद्दल आपण जरा आपलं मत या ठिकाणी तरुणांना सांगावं.
नमस्कार. फार मोठा विषय. आपण आयुष्यभर जोपर्यंत आपण काळा कोट घालणार आहोत तोपर्यंत हा प्रत्येकाने लक्षात ठेवला पाहिजे. आणि ज्याचा उल्लेख आता केला की थिअरी आणि प्रॅक्टिकल याच्यामधले जे काही जमीन आसमानाचा फरक आहे, त्याच्यामध्ये हा फरक कमी करण्यासाठी हा विषय कायम जोपर्यंत काळा कोट घालतोय तोपर्यंत आपल्या लक्षात ठेवला पाहिजे. आम्ही असं कायम म्हणतो की काळा कोट ही आपली कवच कुंडलं आहेत. आपण हिस्ट्रीमध्ये ऐकलेलं आहे, मायथॉलॉजिकल स्टोरीज मध्ये आपण समजलेलं आहे आपल्याला कवच कुंडलं म्हणजे काय असतं. त्यामुळे फार सोपं आहे की जोपर्यंत आपण काळा कोट घालून काम करतोय तोपर्यंत या काळा कोटाचं संरक्षण आपल्याला मिळणार असतं. पण जर आपण या काळ्या कोटाची जर का शान मेंटेन करू शकला नाहीत, राखू शकला नाहीत, मग जे काही घडतं ते डेकोरम मेंटेन न केल्यासारखी घटना घडते. उदाहरण द्यायचं झालं तर न्यायालयामध्ये जे न्यायाधीश साहेब आहेत त्यांना जो न्याय निवारा करण्यासाठी त्यांना तिथे बसवलेलं आहे, ते काम करत असताना त्यांना आपण मदत करायची असते. ही मदत करताना जर आपण वेडवाकडं जर का कृत्य केलं तर ते या डेकोरमशी विसंगत होतं. जे काही सभ्यतेचे संकेत आहेत ते आपल्याला पाळले पाहिजेत. म्हणजे त्या न्यायालयामध्ये शिरताना बाहेर पडताना ज्या प्रकारे आपण वागतोय याच्यातून उरलेल्या समाजाला एक मोठा संदेश जात असतो. आपण त्या न्यायाधीशांना जर का मान दिला नाही तर त्यातून जो लिटिगंट आहे त्याच्या मनावरती काय परिणाम होणार असतो याचा विचार करायला. ते डेकोरम मेंटेन करण्याच्या सगळे जे काही आपल्यावरती बंधनं आहेत त्या बंधनांचा एकदा जर आपण विचार केला तर लक्षात येईल की न्यायालयीन भाषा ही एक वेगळ्या प्रकारची आहे. जेव्हा न्यायाधीशांना आपण सामोरं जाताना कसं बोललं पाहिजे आणि ते बोलताना कसं डेकोरम मेंटेन केला पाहिजे याचा विचार केला. 2 वकिलांमधलं जे बोलणं आहे ते जर न्यायालयामध्ये घडत असेल तर ते कशा प्रकारे आपण आपल्या मित्राला म्हणतो, म्हणजे ज्याला इंग्रजीमध्ये माय लर्नेड फ्रेंड असं म्हटलं जातं, ते आपण का वापरतो, त्यातून तो सभ्यतेचे संकेत आणि जे काही एक आपण म्हणतो डेकोरम मेंटेन करणं याचा विचार आपण करायला. कोर्ट हॉलच्या बाहेर आल्यानंतर कोर्टाच्या कॅम्पसमध्ये आपण कशा प्रकारे वावरतो याच्यावरती आपण डेकोरम मेंटेन करतो का नाही बघणं शक्य. बार काउन्सिल ऑफ महाराष्ट्र अँड गोवाच्या कलम 35 ऍडव्होकेट ऍक्टच्या अंतर्गत अनेक प्रकरणं येतात ज्याला आपण डिसिप्लिनरी केसेस म्हणतो, ज्याला प्रोफेशनल मिसकंडक्ट किंवा अदरवाईज मिसकंडक्ट म्हणतात. ज्या प्रोफेशनल मिसकंडक्टच्या केसेस आपल्याला लगेच सांगू शकतो, कारण
आदरणीय चीफ जस्टिस ऑफ कर्नाटक हायकोर्ट त्यांनी आपल्याला प्रोफेशनल इथिक्स बद्दल सांगितलं, त्याचा भंग झाला की ते सेक्शन 35 मध्ये केस बसते. पण जर डेकोरमचा जर भंग झाला तरी देखील 35 मध्ये बसू शकते, की ज्याला आपण अदरवाईज मिसकंडक्ट म्हणतो. आणि त्याच्याकरताचे अनेक न्यायिक निवाडे आपल्याला बघायला मिळू शकतात. दे आर सेइंग दॅट ऍडव्होकेट इज अ ऍडव्होकेट फॉर 24 आवर्स. त्यामुळे समाजामध्ये जाताना सुद्धा आपण सभ्यतेनंच जायला पाहिजे. कोर्ट कॉम्प्लेक्सच्या बाहेर गेल्यानंतर सुद्धा आपल्याला सभ्यतेनंच वागलं गेलं पाहिजे. आपण ज्या पद्धतीनं रिॲक्ट होतोय त्याच्यावरून समाजाच्या वकिलांकडे बघण्याचा आणि पर्यायानं या व्यवस्थेकडे बघण्याचा दृष्टिकोन कसा आहे हा त्याच्यावरती लगेच ठरणार असतो. त्यामुळे खूप मोठी जबाबदारी आहे. पण याचा अर्थ असा आहे का की डेकोरमच्या दबावामुळे आपण व्यक्तच व्हायचं नाही? नाही, व्यक्ती स्वातंत्र्य आपल्या सगळ्यांना आहे, आपण सगळेजण बोलू शकतो. मग काय बरं यंत्रणा आहे? मग आपली बार असोसिएशन त्या ठिकाणी, ते बार असोसिएशन आपल्या प्रातिनिधिक स्वरूपामध्ये ज्या काही अडचणी असतील त्या अडचणींना उत्तर शोधू शकते. बार असोसिएशनच्या पाठीशी बार काउन्सिल आहे. महाराष्ट्रामध्ये असे जवळजवळ 450 बार असोसिएशन्स आहेत की ज्या बार असोसिएशन या बार काउन्सिल बरोबर नियमाच्या अंतर्गत त्या अफिलिएट झालेल्या आहेत. तर ही सगळी सेफ्टी वॉलची एक यंत्रणा आहे. माननीय उच्च न्यायालय, सर्वोच्च न्यायालयाचं एक्स कॅप्टन हरीश उप्पल निकालपत्र केव्हा तरी वाचून बघा, आपल्याला आता गुगलवरती पण ते बघायला मिळेल. सुप्रीम कोर्ट असं म्हणतंय की आपल्या सगळ्या मागण्या ज्या असतील त्या मागण्यांकरताची एक स्वतंत्र यंत्रणा निर्माण केलेली आहे. ही यंत्रणा काय आहे, कशी आहे हे आपण समजून घेतलं पाहिजे. आपण काळा कोड घातल्यानंतर आपण ट्रेड युनियन सारख्या एखाद्या असोसिएशनचा मेंबर बनतो का? नाही. आपण एखाद्या सामान्य माणसासारखे बनतो का? नाही. आपला वर्ग वेगळा आहे. तो जो काळा कोट आहे त्या काळ्या कोटाची आपल्यावरती असणारी जबाबदारी समजून घेतली पाहिजे. आणि त्याच्यामुळे मग निर्माण होणारे जे प्रश्न असतात किंवा आपल्याला एखाद्या घटनेच्या संदर्भात जर का ताबडतोब प्रतिक्रिया द्यायची असेल ती कशी दिली गेली पाहिजे, ती चौकटीमध्ये असली पाहिजे. आपण वापरलेले शब्द कसे असले पाहिजे ते चौकटीमधले असले पाहिजे. आपण ज्या प्रकारे असोसिएशन म्हणून रिॲक्ट करतोय त्याच्याबद्दल असलं पाहिजे. किंवा ही सगळी गोष्ट आपल्याला माहिती असणं आवश्यक आहे. कारण सगळ्यात महत्वाचं की ही जी यंत्रणा आहे या यंत्रणेचे आपण एक अविभाज्य घटक बनणार आहात. वी आर इनडिस्पेन्सिबल पार्ट ऑफ दिस एंटायर लिगल सिस्टम. आपण जर का तिथले अविभाज्य घटक असू तर आपल्यावरती देखील तेवढीच जबाबदारी येणार आहे की जी त्या न्यायाधीश महाराजांवरती पण असणार आहे. त्यामुळे हे समजून घेतलं पाहिजे की आपण आता ऑर्डिनरी माणूस नाही. सनद मिळाली, काळा कोड घातला, कोर्टात हजर झालो की आपल्या खांद्यावरती मोठी जबाबदारी आलेली आहे. त्या काळ्या कोटाची कवच कुंडलाची जबाबदारी ओळखणं म्हणजेच डेकोरम मेंटेन करणं असं मला म्हणता येईल. धन्यवाद.
कवच कुंडल काळ्या कोटाची ही लक्षात ठेवलं पाहिजे. काळा कोट घालून एकदा ब्रँड घातला आपण की आपण सर्वसामान्य माणसापासून एक लॉ ऑफिसर, विधी अधिकारी या पदावर बसतो. आणि ज्याप्रमाणे न्यायाधीश 24/7 24/7 न्यायाधीश असतो, तो केवळ सकाळी 11 ते 5 या वेळामध्ये न्यायाधीश नसतो. त्याचप्रमाणे वकील देखील 24/7 वकील असतो. त्याच्या प्रत्येक व्यक्तिगत, सामूहिक अशा कृत्यांना त्याच्याकडे एक जबाबदारीनं पाहावं लागतं आणि त्याच्यात काही चुकलं तर त्यावर त्याची कारवाई देखील होते. हे मित्रांनो, नवीन लोकांनी, नवीन वकिलांनी आपल्या समोरचा एक नवा विचार घेऊन ठेवला पाहिजे. आणि त्यासाठी अनेक बारीक सारीक गोष्टी आहेत, अनेक नियम आहेत, त्याचा सकाळी काही प्रमाणामध्ये ओक साहेबांनी उल्लेख केला. आपल्याला एनरोलमेंट सोबत आम्ही एक प्रोफेशनल इथिक्सचं छोटी पुस्तिका दिली आहे. मला असं वाटतं की या पॅन्डेमिकच्या थोड्या रिकाम्या वेळामध्ये ती उघडून बघितली पाहिजे. व्हॉट इज युअर ड्युटी टुवर्ड्स युअर क्लायंट, व्हॉट इज युअर ड्युटी टुवर्ड्स युअर कलीग, व्हॉट इज युअर ड्युटी टुवर्ड्स कोर्ट, व्हॉट इज युअर ड्युटी टुवर्ड्स द सोसायटी. हे सगळे त्यामध्ये तपशीलवार दिलेले आहेत आणि मला असं वाटतं की ते नवीन आलेल्या वकिलांना पाहणं गरजेचं आहे. आता सकाळपासून तुम्ही हा शब्द ऐकलेत, प्रोफेशनल इथिक्स ऐकलाय, प्रोफेशनल कंडक्ट ऐकलाय, प्रोफेशनल मिसकंडक्ट देखील ऐकलाय. हे काय आहे नक्की प्रोफेशनल मिसकंडक्ट? याची काय तक्रार होते, ही काय संकल्पना आहे? मला असं वाटतं की ही देखील थोडी तुम्ही समजून घेणं गरजेचं आहे. कारण आता आपण सनद होल्डर झालेलो आहोत, लायसन्स आपल्याजवळ आहे, आपण आता व्यवसाय करणार आहोत, कोणाचं तरी वकीलपत्र घेणार आहोत, त्याच्याकडनं 2 पैसे फी स्वीकारणार आहोत, मग आपली जबाबदारी काय हे समजणं आणि ती जबाबदारीचा जर भंग झाला तर त्याच्याबद्दल तुमच्यावर कारवाई होऊ शकते. म्हणून मी आमचे सदस्य अविनाश आव्हाड यांना सांगतो की ही नक्की काय संकल्पना आहे, कंप्लेन कशी होते, काय मिसकंडक्ट याबद्दल जरा आपल्याला माहिती द्यावी.
नमस्कार. नवीन वकील एनरोल झाला की बऱ्याच जणांचा समज असा होतो की आता बार काउन्सिलचं काम संपलंय आणि एकदा का आपण एनरोल झालो आणि आपल्याला बार काउन्सिलने एनरोल केलं की बार काउन्सिलचा पुढे आपल्यावर कंट्रोल नाही. पण तसं नसून ऍडव्होकेट्स ऍक्ट प्रमाणे जसं एक कार्य बार काउन्सिलचं नवीन वकिलांना एनरोलमेंट देण्याचं आहे, तसंच लीगल प्रोफेशन मध्ये त्याचे स्टँडर्ड्स आणि त्याचे एथिक्स मेंटेन राहण्यासाठी ती पण जबाबदारी बार काउन्सिलवर आहे. आणि कुठेही काही ब्रीच झाला तर मग सेक्शन 35 प्रमाणे वकिलांवर ऍक्शन होते. बऱ्याचशा नव वकिलांचा असा समज असतो की आता आपण वकील झालो, आपल्यावर काय कोण ऍक्शन घेणार. तर एखाद्या वकिलाने वकील म्हणून काम करताना जर काही कृत्य झाला असेल आणि त्याची तक्रार करायची असेल तर अशा वकिलांच्या अशिलांना सेक्शन 35 प्रमाणे बार काउन्सिलकडे तक्रार करता येते. बार काउन्सिलमध्ये आमच्याकडे एक सिंगल मेंबर कमिटीकडे पहिली ती केस आलोट होते. प्रायमा फेशी त्याच्यावर एक हिअरिंग होतं की ज्या अशिलाने तक्रार आपल्या वकिलाच्या विरुद्ध केली असेल त्याच्यात काही तथ्य आहे का, ती केस पुढे चालवावी का, आणि नसेल तर तिथेच डिसमिस होतं. इथपर्यंत सोपं आहे. पण मात्र जर प्रायमा फेशी सिंगल मेंबरला असं वाटलं की या तक्रारीत तथ्य आहे आणि तिथून पुढे ती तक्रार पाठवली पाहिजे किंवा त्याच्यात बार काउन्सिलने दखल घेतली पाहिजे, मग मात्र थोड्याशा गोष्टी सिरियस व्हायला लागतात. कारण तिथून पुढे ती केस एक 3 मेंबर कमिटीकडे जाते ज्याच्यात 2 इलेक्टेड बार काउन्सिल मेंबर्स आणि एक कोऑप्टेड मेंबर असतात. ही एक क्वसाई सिव्हिल ट्रायल असल्यासारखी होते. पूर्ण ट्रायल होते ज्याच्यात साक्षी पुरावा नोंद केला जातो आणि बार काउन्सिल मेंबर्सचे 3 मेंबर कमिटी त्याच्यात पूर्णपणे एक जजमेंट देतं ज्याच्यात एखाद्या वकिलाला वॉर्निंग देण्यापासून किंवा काही महिने ते वर्ष सस्पेंड करण्यापर्यंत सनद किंवा काही केसेसमध्ये परमनंटली रोलवरनं रिमूव्ह करण्यापर्यंत सुद्धा शिक्षा देण्याचे अधिकार हे बार काउन्सिलला आहेत. म्हणून सगळ्या नवीन एनरोल झालेल्या वकिलांना विनंती राहील की या सगळ्या गोष्टींची काळजी घेऊनच आपण प्रॅक्टिस केली पाहिजे. बार काउन्सिल ऑफ महाराष्ट्र आणि गोवाचा जो निर्णय असतो किंवा कुठल्याही स्टेट बार काउन्सिलचा 3 मेंबर कमिटी जर निर्णय झाला तर त्याच्या विरुद्ध बार काउन्सिल ऑफ इंडियामध्ये डायरेक्ट अपील आहे. स्टेट मधल्या दुसऱ्या कुठल्याही कोर्टाला अथॉरिटी नाही आणि बार काउन्सिल ऑफ इंडियाच्या निर्णयाविरुद्ध डायरेक्ट सुप्रीम कोर्टात आहे. त्यामुळे ही सगळी प्रक्रिया जी आहे ती सिरियस आहे, त्याच्यात थोडं लक्ष घालावं. आपल्याकडे रूल्स ऑफ प्रोफेशनल कॉन्डक्ट आणि प्रोफेशनल इथिक्स आहेत ते एकदा बघून घ्यावे. आणि थोडे उदाहरण आपल्याला द्यायचे म्हणजे नवीन काळामध्ये साधारण वकिलांना जास्त काम एक सर्च अँड टायटल रिपोर्ट असतो किंवा सिनियर सांगतात बरेच वकील आले पार्टिशन सूट असेल 30 ते 40 समजा एखाद्या पार्टी असतील तर सिनियर सांगतात त्यांचे वकीलपत्र घ्या. अशा काही छोट्या छोट्या गोष्टी ज्या आपल्याला वाटतात की फार काही महत्वाच्या नाहीत, पण आमचा एक अनुभव असा आहे की बार काउन्सिलकडे एक मोठा नंबर केसेसचा ज्युनियर्सच्या अगेन्स्ट हा आहे. आता सर्च अँड टायटल रिपोर्ट जर एवढं सिंपल वाटतंय तर मग ह्याच्यात काय कंप्लेंट होऊ शकते. तर आमच्या बघण्यात असं आलेलं आहे की बऱ्याच वेळेला ज्युनियर्सने जर सर्च अँड टायटल रिपोर्ट देताना काही गोष्टींची काळजी घेतली जात नाही. त्या सर्च अँड टायटल रिपोर्ट मध्ये कुठेतरी एंट्रीज काही नसतात. आपल्याकडूनही कधी कधी घाई होते म्हणा किंवा तेवढी काळजी घेतली नाही जात आणि आपण जर तो सर्च अँड टायटल रिपोर्ट दिला ज्याच्यावर एखाद्या प्रॉपर्टीचा व्यवहार होतो, खरेदी विक्री होते आणि अशा वेळेला जर खरेदी घेणाऱ्याला ते घेतल्यानंतर जर कळलं की त्या प्रॉपर्टीमध्ये काही डिफेक्ट होता, त्याचा टायटल डिफेक्टिव्ह होतं आणि त्याच्यामुळे जर त्याला पुढे कोर्टात जायला लागलं तर अशा वेळेला असा अशील हा त्या वकिलांच्या विरुद्ध बार काउन्सिलमध्ये तक्रार करू शकतो. त्यांच्या विरुद्ध कधी कधी बऱ्याच वेळेला अशा व्यवहारांमध्ये पोलीस केसेस होतात आणि मग प्रश्न असा पण येऊ शकतो की वकील त्याच्यात पार्टी होते का नाही. अशा थोडे सिरियस गोष्टी असल्यामुळे आपण सर्च अँड टायटल रिपोर्ट करताना काळजीपूर्वक केले पाहिजेत. तो एक वेगळा विषय जो बार काउन्सिल नेहमी ते लेक्चर्स घेत आलेले आहेत, तर आपण तेही काळजीपूर्वक ऐकावे. छोटंसं कार्य आपलं असतं की आपल्याकडे अशी आला की आपण त्याची वकीलपत्रावर सही घेतो आणि ती सही घेऊन वकीलपत्र आपण कोर्टात दाखल करतो. याच्यात काय मिसकंडक्ट होणार असं वाटतं. पण बऱ्याच वेळेला असं अनुभवलंय की खूप सारे क्लायंट असतील तर समोर आपल्या क्लायंट नसताना त्यांची सही घेतली जाते, वकीलपत्र कोर्टात फाईल केलं जातं. कधी कधी त्याच्यावर काही निकाल होतो आणि नंतर समोरची पार्टी येऊन तक्रार करते की ती माझी सही नाहीच किंवा मी तिथे हजर नव्हतेच. असं जर झालं तर मग कदाचित त्या वकिलावर डायरेक्ट ऍक्शन होऊ शकते. कारण जेव्हा जेव्हा वकील तिथे वकीलपत्र दाखल करतात कोर्टात तेव्हा आपल्याला एक ऑफिसर ऑफ द कोर्ट म्हणून आपल्यावर जो विश्वास ठेवलेला असतो की हे जे वकीलपत्र वकिलांनी सादर केलं आहे कदाचित त्यांनी ते सगळं काळजी घेतलेली आहे, समोरचा माणूस आलेला आहेच त्याच्यासमोर आणि सही केलेली आहे. म्हणून मी आपल्याला विनंती करेल की आपण जेव्हा वकीलपत्र घ्याल तेव्हा प्रत्येकाचे आपण आधार कार्ड बघा किंवा काहीतरी आयडेंटिफिकेशन बघून मगच त्या सह्या केल्या गेल्या पाहिजेत. कारण कोर्ट आपल्यावर विश्वास ठेवतं आणि पुढे ऑर्डर झाल्या की त्याचे फार सिरियस कॉन्सिक्वेन्सेस असतात. तिसरं आम्ही एक जे कायम बघितलंय की सर्च अँड टायटल रिपोर्ट असेल, वकीलपत्र असेल, हे अशा छोट्या छोट्या गोष्टींमुळे इतके सिरियस कॉन्सिक्वेन्सेस झाले तर कधी कधी वकिलांची सनद आम्हाला सस्पेंड करायला लागते. नवीन काळामध्ये जर एखाद्या वकिलाच्या विरुद्ध असं काही झालं तर त्याला फार सिरियस ऍक्शन होते आणि मग पुढेच करिअरच परमनंटली खराब होऊ शकतं. म्हणून मग आपल्याला विनंती आहे की अशा छोट्या छोट्या गोष्टींकडे लक्ष देऊन पूर्ण काम करून मगच हे पुढे आपली वकिली चालवावी अशी एक विनंती आहे. धन्यवाद.
हा एक अतिशय त्याच्यामुळे बारकाईनं बघण्याचा विषय आहे. प्रोफेशनल कंडक्ट काय, प्रोफेशनल मिसकंडक्ट काय, या सगळ्या गोष्टींकडे मला असं वाटतं की त्यामुळे आपण लक्ष ठेवलं पाहिजे, त्याचं वाचन केलं पाहिजे. त्याच्या येणाऱ्या केसेस, मी माझ्या नावाचा बोर्ड केला तर तो किती साईजचा असेल हे देखील प्रोफेशनल इथिक्स मध्ये पाहिलं जातं. तो 2x1.5च्या वर तर तुम्ही 10x4चा बोर्ड केला तर तुम्हाला रिपोर्टेड केसेस आढळतील की दॅट इज अ मिसकंडक्ट ऑफ द लॉयर. एवढा मोठा बोर्ड करून जर कोणी आपला वकील म्हणून करत असेल तर ती प्रसिद्धी म्हटलं जातं. अशा प्रकारच्या अनेक बारीक सारीक गोष्टी या प्रोफेशनल इथिक्स, कंडक्ट आणि मिसकंडक्ट मध्ये येतात आणि त्याच्यामुळे आपण आपलं काम करताना दक्षपणे त्या सगळ्या समजून घेऊन वकील म्हणून काम केलं पाहिजे. वकिलीमध्ये अश्वित देशमुख सरांनी सांगितलं की 9,000 9,500 दरवर्षी एनरोल होतात. या एनरोलमेंटची संख्या जर बघितली याच्यामध्ये निम्मी संख्या ही महिलांची असते. लेडी ऍडव्होकेट्स आपल्या भगिनी देखील मोठ्या प्रमाणामध्ये वकिलीमध्ये येत आहेत. चांगली गोष्ट आहे, स्वागतार्ह गोष्ट आहे. आणि मग अशा परिस्थितीमध्ये या सगळ्या महिलांचे कामकाज करताना देखील काही विषय समोर येतात, अडचणी येतात. त्यांना देखील काही चॅलेंजेस आहेत, वेगळे आहेत. त्यांचं प्रमाण देखील लॉंग टर्म मध्ये तेवढं व्यवसायामध्ये राहत नाही आणि काही निमित्तानं महिला वकील त्याबद्दलचे काही विषय समोर येतात. आमचे बार काउन्सिल मेंबर ऍडव्होकेट पठाण सर यांना मी सांगतो की त्यांनी त्याबद्दल आपलं मार्गदर्शन करावं. First of all, I welcome you all for joining this noble profession. But before I could give the answer to the query, let me tell you something about a guru of my guru, in whose memory Bar Council has taken this initiative to start with this basic legal education program. When this subject was discussed in the Bar Council, we all unanimously why we have taken the decision. You junior or newly entered in this profession may not be known about the contribution of the great late Bhaskar Award sir. Our chairman has in his speech mentioned that a Bhishmacharya, म्हणजे विधी क्षेत्रामधील आमच्या सगळ्यांचे गुरु. And I thank God that after 1985, in this Bar Council, it's a combination of academician
as well as the practicing lawyer, which was not earlier. And therefore, simply giving a sanad, that is not the function of the Bar Council, but even to see and to protect an interest and safeguard the interest of the advocate on his role. But at the same time, for their upliftment and betterment, why they are not to be equipped with the latest knowledge, the subject which were not taught to us, but the new subjects are now in the syllabus. So we must be updated with the new knowledge, and that is why मराठीमध्ये थोडंसं सांगतो, ज्याला पळभर म्हणतील हाय हाय तू जाता राहील कार्य काय. सरांच्या कार्याची बार कौन्सिलने दखल घेतली. सरांनी 2 टर्म, त्याच्यानंतर माझे गुरु सुधाकर अवाल यांना तुम्ही ऐकलं त्यांची 1 टर्म, आणि त्यांचे चिरंजीव जे माझ्या शेजारी बसलेत अविनाश अवाल सर यांच्या 3 टर्म्स. चिंचोली सारख्या पाथर्डी तालुक्यात नगर जिल्ह्यातून आलेलं हे कुटुंब सकाळी कुंभकोणी सरांनी सांगितल्याप्रमाणे की आम्हाला कुठलाही वारसा नव्हता. वी आर नॉट द प्रॉडक्ट ऑफ द लिगॅसी ऑफ दिस प्रोफेशन. हा सर. येस 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 आय नो, बट फ्यू वर्ड्स इन हिज मेमरी. दुर्दैवाने आम्ही त्यांच्या अंत्यविधीलाही या सिच्युएशन मध्ये जाऊ शकलो नाही. सरांचं अंतिम दर्शन आम्हाला घेता आलं नाही. इट वॉज अनटाइमली डेथ. पण बार कौन्सिलने त्याची ही दखल घेऊन तुम्हा लोकांना बेसिक लिगल एज्युकेशन देण्याचा हा जो पायंडा उचलला किंवा पाऊल उचललं, याच्यामध्ये आमचे मार्गदर्शक आमचे जयंतराव आहेत आणि आशिष देशमुख. तर आपल्याला ह्या माध्यमातून अनेक आम्ही उपक्रम आणि चांगले लेक्चर्स वगैरे देणार आहोत. नाउ coming to the lady advocate, today in our role there are more than 20% female advocates, and you could see even in the judiciary, even last JNFC result, then you could witness that there are more than 40% female advocates who have joined the judiciary. Therefore, there is a tremendous scope in every field or walk of life today. The female have entered. Sex is no bar. I could give the example, the first lady judge in the Supreme Court, Bibi Fatima. Thereafter, Sujata Manohar. Then Ranjana Desai Madam from Nasik, who was elevated even to the Supreme Court. These are the few examples for a female advocate, lady advocate. I know because of the family problem. Family problem because she is a daughter, she is a wife, she is a mother, and she has to perform all these multifaceted activities. Sometimes there is a restraint. आमच्या बार कौन्सिल मध्ये हा एक विषय आला होता की वकिलांना कोणी मुलगी देत नाही. म्हणजे बाप मुलीचा असं म्हणतो, मुलीला मी विहिरीत ढकलून देईल पण वकिलाला मुलगी देणार नाही. अशी ही जी काही संकल्पना समाजामध्ये होती ती आता संपलेली आहे. मुलगी वकील आहे म्हणून तिच्या लग्नाचे अनेक प्रश्न निर्माण होतात. लग्न झाल्यानंतर तिने वकिली करू नये म्हणून तिच्यावर बंधने टाकली जातात. पण माझी कन्या, आय एम प्राऊड टू से that the last degree of law, that is, she has completed her PhD, so she is doctor, and now she is a best lecturer than me in the Bharati Vidyapit. I requested my daughter-in-law, आता तुझी मुलं मोठी झालीत, लॉला ऍडमिशन घे. आपल्याला आपल्या कुटुंबियांना थोडस त्यांची मनधरणी करून, म्हणजे आपला पती असेल, आपले सासू सासरे असतील, आपले जे महिला वकिलांचं ह्या क्षेत्रातून एनरोलमेंट झाल्यानंतर जो ड्रॉप आउट होतोय, ती जी संख्या आहे त्याची आम्हा बार कौन्सिलला जास्त चिंता आहे. आणि म्हणून महिला वकिलांनी शक्यतो ह्या करिअरकडे, याच्यामध्येही आपण चांगलं करिअर घडवू शकतो हे महिलांसाठी सांगतो. ठीक है, बेटियां हर घर में कहां पैदा होती है? अरे उसी के घर में पैदा होती है जहां उसकी रहमत बरसती है. आणि मी सुद्धा स्पर्शू शकते आकाश, फक्त संधी मिळण्याचा अवकाश, फक्त संधी मिळण्याचा अवकाश. त्यामुळे मी महिला वकिलांना विनंती करेल की या क्षेत्रामध्ये चांगलं करिअर न्यायाधीश म्हणून, प्राध्यापक म्हणून, वकील म्हणून आणि आपलं चांगलं नाव आपण करू शकतो. त्यामुळे आपण निराश होऊन हा व्यवसाय सोडू नये ही सगळ्यांना विनंती. निराश होऊ नये. पठाण सरांनी जे सांगितले ते लक्षात ठेवावं तेवढं, आणि महिलांनी जास्तीत जास्त प्रॅक्टिस मध्ये कायम राहावं, विड्रॉ होऊ नये. कारण स्टॅटिस्टिक असं दाखवतं की संख्या जास्त असते एनरोलमेंटची, पण तो कायमस्वरूपी प्रॅक्टिस मध्ये मात्र राहण्याचं प्रमाण कमी आहे. बार काउन्सिल त्यासाठी महिलांच्या ज्या अडचणी आहेत त्याच्याकरता सातत्यानं त्यांच्या पाठीशी आहे. आता दिवाणी काम हा एक महत्वाचा भाग आहे. दोन, दिवाणी आणि फौजदारी. मी पहिल्यांदा दिवाणी या कामाकडे येतो. दिवाणी दाव्यांचं आणि दिवाणी एकंदरच कामाचं जिल्हा न्यायालय, तालुका न्यायालय किंवा उच्च न्यायालयाच्या मधलं स्वरूप थोडं बदललं आहे. दिवाणी कामामधले आमचे ज्येष्ठ असे विधिज्ञ माजी अध्यक्ष वसंतराव भोसले इथे आहेत. मी त्यांना विनंती करतो की आपल्याला कसं काय दिसतंय आता दिवाणीचं स्वरूप, चेंज सिव्हिल प्रॅक्टिस, याबद्दल थोडं तरुणांना मार्गदर्शन करावं.
नमस्कार मित्रांनो. खरं तर आपण वकील झालो, सनद घेतली की आपण कुठं प्रॅक्टिस करायचं हा नवीन वकिलांपुढे एक प्रश्न असतो मोठा. अट्रॅक्शन नक्की असतं की फौजदारी वकिलीकडे जास्त लोकांचं अट्रॅक्शन असतं, प्रसिद्धी मिळते, मोठमोठ्या केसेसमध्ये कुठेतरी वर्तमानपत्रात नाव येतं आणि त्या माध्यमाचं थोडंसं अट्रॅक्शन वकिलांच्या मनामध्ये असतं. परंतु फौजदारी वकिली आणि दिवाणी वकिली याच्यामध्ये जे अंतर आहे, हे अंतर जर आपण विचार करायला गेलो तर सगळ्यात जास्त वाव दिवाणी वकिलीमध्ये आहे. वकिलाला सगळ्यात जास्त मोठं करिअर करण्याची संधी दिवाणी वकिलीमध्ये आहे. त्याचं कारण मी असं सांगेन की पूर्वी दिवाणी वकील म्हणजे फक्त JMFC किंवा ज्युनियर डिव्हिजन, सिनियर डिव्हिजन, जिल्हा कोर्ट एवढंच मर्यादित होतं सुरुवातीच्या काही काळामध्ये. परंतु नंतर वेगवेगळे कायदे येत गेले. दिवाणी कोर्टातलं काम हळूहळू वेगवेगळ्या ट्रायब्युनलमध्ये विभागलं गेलं. परंतु असं जरी विभागलं जरी केलं असलं तरी ते दिवाणी स्वरूपाचं काम असतं. तर त्या अनुषंगाने मी म्हणून की लेबर कोर्ट असेल, इंडस्ट्रियल कोर्ट असेल, कोऑपरेटिव्ह कोर्ट असेल, फॅमिली आता नवीन अस्तित्वात आलेली फॅमिली कोर्ट्स असतील, रेरा खालची काही प्रकरण असतील, डेट ट्रायब्युनल्स असतील, अशा अनेक वेगवेगळ्या फॅकल्टीज या दिवाणी कायद्याच्या कक्षेमध्येच किंवा सिव्हिल प्रोसिजर कोडला अनुसरूनच या सगळ्या गोष्टी पुढे आलेल्या असतात. आणि त्यामुळं याच्यामध्ये करिअर करण्यासाठी दिवाणी वकिलांना किंवा नवीन येणाऱ्या वकिलांना या वेगवेगळ्या फॅकल्टीकडे विचार करण्यासाठी किंवा या वेगवेगळ्या फॅकल्टीमध्ये आपल्याला कुठे इंटरेस्ट आहे त्या क्षेत्रामध्ये जाण्यासाठी सुद्धा एक तशा पद्धतीचा विचार आपण करू शकता. आपण फक्त जिल्हा न्यायालयाच्या इमारतीत गेलो म्हणजेच दिवाणी वकिली केली किंवा तालुका कोर्टात गेलो म्हणजेच वकिली केली असं नाही. तर आपल्याला ह्या वेगवेगळ्या फॅकल्टीज मध्ये जर काम करायचं असेल तर त्यासाठी या नवीन आलेल्या कायद्यांचा दिवाणीतल्या स्वरूपातले जे काही कायदे नवीन वेगळ्या अमेंडमेंट्स आलेल्या आहेत, दुरुस्त्या झालेल्या आहेत आणि या दुरुस्त्या त्याचबरोबर नवीन आलेल्या ह्या काही कायदे अस्तित्वात आलेले आहेत त्याचाही जे आपण कॉलेजमध्ये शिकलेलो नाही, कॉलेजमध्ये हे आपल्याला विषय नव्हते. फॅमिली कोर्ट हा काही वेगळा विषय नसतो, कोऑपरेटिव्ह काही लोकांचा असतो, काही लोकांचा नसतो, किंवा इंडस्ट्रियल कोर्ट, लेबर कोर्ट हे सगळ्याच विद्यार्थ्यांचे विषय नसतात. पण तरी सुद्धा जर आपल्याला सर्वसमावेशक तालुका प्लेसला किंवा जिल्हा कोर्टामध्ये वकिली करायची असेल तर या सगळ्या कायद्यांचा अभ्यास आपल्याला करणं आवश्यक आहे. आणि निश्चितपणाने सांगेन की पहिली 4-5 वर्ष आपल्याकडे तितकं असं काम पुरेसं नसतं. आपण सिनियरच्या ऑफिसला काम करत असतो, आपल्याकडे वाचनासाठी भरपूर वेळ असतो. मित्रांनो, वाचनासाठी ही 4 वर्ष तुम्ही जेवढी इन्व्हेस्टमेंट या वाचनामध्ये जाल तेवढी इन्व्हेस्टमेंट ही तुमच्या आयुष्यभर पुढे पुरणारी आहे. पुढे कदाचित काम वाढत जातं, तुमचं अवांतर वाचनाला वेळ नसतो किंवा बाकीच्या गोष्टी वाचनाला वेळ मिळत नाही. म्हणून आत्ताची येणारी 5 वर्ष तुमची जी आहेत या 5 वर्षामध्ये 4 वर्षामध्ये जोपर्यंत आपण ज्युनियरशिप करतोय तेवढ्या काळामध्ये जास्तीत जास्त वाचन कसं करता येईल, मग ते लॉ फॅकल्टी मधलं असेल, इव्हन अवांतर वाचन सुद्धा जेव्हा आपण करतो तेव्हा एखादं अवांतर वाचनातली एखादी कादंबरी वाचली तर किमान आपण 8 कॅरेक्टर 10 कॅरेक्टर वाचत असतो. आणि ते 10 कॅरेक्टर म्हणजे 10 वेगवेगळ्या प्रवृत्ती असतात. समाजातल्या त्या प्रवृत्तीचा वापर आपल्याला आपल्या केस मांडताना, कोर्टापुढे केस चालवताना, वेगवेगळ्या प्लीडिंग्स घेताना निश्चितपणानं त्या वाचनाचा आपल्याला इकडे उपयोग होतो. एक कादंबरी वाचली, गोष्ट वाचली म्हणजे मी अवांतर वाचन केलं किंवा त्याचा वापर इकडे या व्यवस्थेमध्ये कसा करता येऊ शकतो, कोर्टापुढे मांडताना वेगवेगळे दाखले कसे देता येऊ शकतात. जसं की आता पठाण सरांनी काही वचनं सांगितली, काही वेगळ्या वेगळ्या पद्धतीने सांगितलं, किंवा काही लोकांचे पण भाषणं ऐकतो, त्या भाषणांमध्ये काव्यपंक्ती ऐकतो, तर निश्चितपणानं अशा अवांतर वाचनातून आपली प्रगल्भता आपल्या आर्ग्युमेंट्स मध्ये येत असते. त्यामुळे नुसतं कायद्याचं वाचन करून किंवा बाकीच्या कायद्यातल्या तरतुदी बघून आपण चांगला वकील होऊ शकत नाही. तर दिवाणी वकिलीतलं प्रॅक्टिस चांगल्या पद्धतीने कोर्टापुढे येण्यासाठी तुम्हाला अवांतर वाचनाची निश्चितपणानं गरज आहे. आणि त्या अनुषंगाने कायद्याचं वाचन करत असताना 5 वर्षामध्ये काम करत असताना, ज्युनियरशिप करत असताना, किमान ऑफिसमध्ये ज्या सिनियरकडे आपण काम करतोय त्या सिनियरच्या दिवाणीतल्या 2 ब्रीफ दररोज वाचायच्या. किमान 2 नाही झाल्या तर किमान मी 1 ब्रीफ तरी पूर्ण वाचेन. प्लेंट काय आहे, त्याच्यासोबत कागदपत्र काय दाखल केलेत, एक्सपेक्टेड त्याला WS रिटर्न स्टेटमेंट काय आलंय, रिटर्न स्टेटमेंट मध्ये डिफेन्स कोणकोणते घेतलेले आहेत, त्या अनुषंगाने काही कागदपत्र दाखल केलीत का, आणि मग जर दाखल केली असतील तर ती काय कोणती कागदपत्रे आहेत, हे जर आपण वाचन ठेवलं. त्याचबरोबर जर एखादा अपिलाचा ब्रीफ कधीतरी हळूहळू सुरुवात केली तर त्याच्यामधनं जजमेंट मध्ये काय आलंय आणि ह्या जजमेंट मध्ये काय आलंय, मग अपिलामध्ये कोणते नवीन मुद्दे येऊ शकतात, अशा पद्धतीचा जर आपण अभ्यास दररोज करू शकलो. अवांतर वाचनामध्ये मी सांगतोय कायदा वाचन वेगळं आणि केस वाचन वेगळं. तर अशा पद्धतीचं आपण केस वाचन दररोज किमान 1 ब्रीफ तुम्ही वाचलं तरी महिन्याला 30 मिळत नाही पण 20 ब्रीफ वाचून होतात. 20 वेगवेगळ्या केस झाल्या, वर्षाला 12 महिने होतात, तुम्ही 10 महिने केले तर 200 केसेस तुमच्या वर्षात वाचून झाल्या. तर निश्चितपणाने तुम्हाला इंडिपेंडंट प्रॅक्टिस करायला याची खूप मदत होते. आपण ऑब्झर्व ऑफिस जॉईन करतो म्हणजे आपल्याला सिनियर कुठलाही लेक्चर देत नाही, कुठलंही असं बोटाला धरून हे शिकवत नाही बाबा हे असं बाबा ते तसं. टू ऑब्झर्व अँड टू लर्न. तुम्ही त्या सिनियरकडे पाहायचंय तो लोकांशी कसा बोलतोय, कसा वागतोय, कशी त्याला ट्रीटमेंट देतोय, त्याच्याकडनं इन्फॉर्मेशन कशी कलेक्ट करतो. तो माणूस समोरचा माणूस बसला हे 100% आपल्याला खरं सांगत नसतो, तो त्याची चांगली बाजू सांगत असतो, पण ती त्याच्यातली आणखी दडवलेली बाजू बाहेर काढण्यासाठी कोणकोणते स्किल आपला सिनियर वापरतो. ही सगळी स्किल्स तुम्हाला त्या ऑफिसमध्ये सिनियरच्या बाजूला बसून शिकायची असतात, त्यांच्याकडे पाहून त्या सगळ्या गोष्टी करायच्या असतात. आणि मग अशा पद्धतीनं जर तुम्ही ऑफिस सिन्सिअरली केलं, सिन्सिअरिटी हा फार महत्वाचा पार्ट आहे. सिन्सिअरली, कारण मी 1 दिवस 9ला ऑफिसला येणार, 1 दिवस 10ला येणार आणि संध्याकाळी ऑफिसला बसणारच नाही. सिव्हिल प्रॅक्टिस मध्ये तुम्हाला सकाळी 8:30 पासून रात्री 10 पर्यंत ऑफिस करायची मनाची तयारी ठेवा. 4 वर्ष द्या, तुम्हाला आयुष्यभर ही 4 वर्षात केलेली मेहनत आयुष्यभर पुरेल आणि तुम्ही यशस्वी वकील नक्की व्हाल. तुम्हाला शुभेच्छा. धन्यवाद.
चांगल्या पद्धतीनं दिवाणी प्रॅक्टिसचे किती कवाडे उघडलेली आहेत हे वसंतराव भोसलेंनी आपल्यासमोर मांडले. खूप तपशीलवार विषय आहे. अनेक नवीन कायदे आलेले आहेत, अनेक नवीन फोरम्स उपलब्ध आहेत, ट्रिब्युनल्स उपलब्ध आहेत, कामं उपलब्ध आहेत. आपण त्याचा शोध घेतला पाहिजे आणि त्या नवीन कामांमध्ये आपण आपल्याला अवगत केलं पाहिजे. की केलं तर मला असं वाटतं की हा जो काही वेटिंग पिरियड सांगितला जातो व्यवसायामधला तो दूर झाल्याशिवाय राहणार नाही. आणि दुसरी गोष्ट म्हणजे दिवाणी प्रक्रियेमध्ये तुम्ही काम कराल, दिवाणी प्रॅक्टिस कराल तर ते तुम्हाला लॉंग टर्म त्या प्रोफेशन मधला बेस तयार करेल. अशा पद्धतीचा विचार करूनच दिवाणी प्रॅक्टिस कडे बघावं. कारण बरेच वेळा आम्ही बघतो की तरुण असं म्हणतात नको बाबा ते कोण सिव्हिलला जाईल, इतके कायदे, ते CPC, ते CR एवढं सगळं बघायचं. या सगळ्या गोष्टींचा कंटाळा न करता त्याकडे आपण अधिक लक्ष द्यावं. या पद्धतीचं दिवाणी प्रॅक्टिसचं हे स्वरूप भोसले साहेबांनी सांगितलं. त्याचप्रमाणे क्रिमिनलचा एक वेगळा अँगल आहे. असं म्हटलं तर क्रिमिनलसाठी कोर्ट 2च आहेत, एक मॅजिस्ट्रेट कोर्ट आणि एक सेशन्स कोर्ट ट्रायल चालवण्याकरता, आणि मग अपिलेट कोर्ट. वेगवेगळे कुठलं ट्रिब्युनल असं क्रिमिनलसाठी झालेलं नाही की ज्याला शिक्षा द्यायची पॉवर आहे माझ्या माहितीप्रमाणे. तर आपल्याकडे संग्राम देसाईंसारखे त्यामधले काम करणारे एक्सपर्ट आहेत. मी त्यांना असं बघेल की सांगेल की ते आजच्या या परिस्थितीमधल्या फौजदारी प्रॅक्टिस, क्रिमिनल प्रॅक्टिस कडे कसं बघतात आणि कोणती दालनं उघडलेली आहेत त्या प्रॅक्टिस मधली ती या तरुणांना त्यांनी सांगावं.
Thank you, sir. Sir, I truly believe कि I don't believe, it's a fact कि law is nothing but common sense. Yeah. So basically, law is nothing but common sense, and therefore, be it civil, be it criminal, if you have common sense, I think you understand both civil as well as criminal. परंतु अशी परिस्थिती आहे
की आजच्या घडीला आपण क्रिमिनल साईडचा जेव्हा विचार करतो ते पहिल्यांदा आपल्याला फक्त आयपीसी खालचे ऑफेन्सेसच डोळ्यासमोर असायचे. परंतु जसजसं आता नवीन नवीन घटना घडतायत, नवीन नवीन लॉज येत आहेत, त्यानुसार क्रिमिनल कोर्टच्या वर्किंग मध्ये देखील बराचसा फरक पडलाय. आणि म्हणून केवळ आयपीसी ऑफेन्सेस लक्षात न घेता, फॉर एक्झाम्पल नार्कोटिक्सचे ऑफेन्सेस आहेत, पॉक्सोचे, आता हा नवीन कायदा आलाय लहान मुलांसंदर्भात, अगदी सिंपल ऑफेन्सेस जरी घेतले आपण, निगोशिएबल इन्स्ट्रुमेंट ऍक्ट आहे, त्याहीपेक्षा अजून सिंपल म्हटलं तर डोमेस्टिक व्हायलन्सचे जे प्रोव्हिजन्स आहेत त्याप्रमाणे जे काही केसेस होतात, नवरा बायकोची भांडण त्या संदर्भात जे काही डोमेस्टिक व्हायलन्सचे गुन्हे घडतात किंवा मॅटर्स येतात, अशी विविध प्रकारची मॅटर्स येऊ लागली आहेत. आणि म्हणून मला असं वाटतं की हे जे नवीन जनरेशन आहे, जसं आपण मेडिकल प्रोफेशन मध्ये आपण एक पाहिलंय की प्रत्येक जण एक वेगळं फील्ड चूज करतो आणि त्या फील्डमध्ये एक्सपर्टीज त्याची असतात, त्यामध्ये भरपूर केसेस करून, भरपूर नीट त्याचा स्टडी करून, पेपर्स लिहून ते एका पर्टिक्युलर फील्डमध्ये फार चांगलं नॉलेज एक्वायर करतात. आणि मला असं वाटतं आजच्या परिस्थितीमध्ये क्रिमिनल कोर्टचं वर्किंग पाहता यंग जनरेशनला एक खूप चांगला स्कोप आहे की त्यांनी कुठलं तरी एखादं स्पेशलायझेशन करावं. फॉर एक्झाम्पल ज्यांना निगोशिएबल अगदी सिंपल केसेसमध्ये मॅटर्स चालवण्याची इच्छा आहे, त्यांनी निगोशिएबल इन्स्ट्रुमेंट ऍक्ट असतील त्याचा नीट अभ्यास करावा. दे कॅन बी एक्सपर्ट इन निगोशिएबल इन्स्ट्रुमेंट मॅटर्स. काही डोमेस्टिक व्हायलन्स मध्ये होतील, काही एनडीपीएस मध्ये होतील, काही करप्शन अँटी करप्शनची जे मॅटर्स असतात त्यामध्ये होतील, काही आयपीसी मध्ये होतील. तर आजच्या घडीला जे भरपूर मोठ्या प्रमाणावरती लॉयर्स एनरोल होत आहेत, जर आपण अशा पद्धतीने प्रत्येक लॉयरनी, यंग लॉयरनी वेगवेगळ्या फील्डमध्ये एक्सपर्टीज मिळवलं तर मला वाटतं प्रत्येकाला त्या पद्धतीचं कामही मिळेल आणि एक चांगल्या पद्धतीचं आउटपुट देखील हे यंग लॉयर्स देऊ शकतील असं मला वाटतं. आणि म्हणून त्या यंग, आपण जे आता तुम्ही यंग लॉयर्स आहात, त्यांनी प्रत्येकाने आपापलं आवडीप्रमाणे फील्ड चूज करायला चालू केलं पाहिजे. जसजसे तुम्ही कोर्टात जायला चालू कराल, तुम्ही मॅटर्स बघाल, वेगवेगळे लॉयर्स कोर्टमध्ये प्रॅक्टिस करताना बघाल, त्यावेळी तुम्हाला तुमची आवड देखील कळायला लागेल की माझा ओढा या पर्टिक्युलर फील्डमध्ये आहे. आणि ज्यावेळी तुम्हाला तुमचा ओढा कळेल, आय बिलीव्ह की तुम्ही त्याच्यामध्ये जास्तीत जास्त अभ्यास करून त्याच्यामध्ये एक्सपर्टीज आपले मिळवा, जेणेकरून तुमची प्रॅक्टिसही चांगली होईल, जे तुम्हाला आवडतं ते देखील तुम्हाला काम करायला मिळेल. आणि म्हणून एक नवीन जे लॉयर्स आहेत त्यांनी एक फक्त क्रिमिनल असं फील्ड न बघता त्या क्रिमिनल मध्ये वेगवेगळी जी नवीन आता दालना आलेली आहेत त्यांचा देखील विचार करणं गरजेचं आहे असं मला वाटतं.
धन्यवाद संग्रामजी. फौजदारीमध्ये केवळ रिमांड आणि जामीन या पलीकडे देखील ज्युनियरशिप पासूनच काम करण्याचा प्रयत्न आपण सगळ्यांनी केला पाहिजे आणि त्यातून अधिक चांगल्या पद्धतीचं क्रिमिनल प्रॅक्टिस आपल्याला करता येईल. थोडा आता आपल्याला काही अतिशय महत्वाच्या मुद्द्यांना शेवटचा स्पर्श करून पुढे जायचं आहे, परंतु एक महत्वाचा मुद्दा जो ज्युनियरच्या हे जरी असलं तरी नक्की सिनियर कडे काम करताना तुम्हाला काहीतरी एक दिशा देण्यासाठी एक थोडंसं मार्गदर्शन, त्यांच्याकडे अनेक ज्युनियर झालेले आहेत ते गजानन चव्हाण करतील. त्यानंतर आपण या चॅलेंजेसच्या विषयाकडनं आता तुमच्या ज्या काही संधी आहेत तुम्हाला त्या काय आहेत हे सांगण्याकरता मी निश्चित आव्हाड सरांना निमंत्रित करणार आहे. तत्पूर्वी मी पहिले गजानन चव्हाणांना सांगतो की सिनियर कडे कसं बघावं, सिनियर कडे काम कसं करावं याबद्दल जरा ज्युनियर वकिलांना मार्गदर्शन करा.
थँक्यू सर. निरीक्षण आणि अनुकरण, टू ऑब्झर्व अँड टू फॉलो, टू ब्रिंग इन प्रॅक्टिस, हा मानवाचा पुरातन गुण आहे. ज्युनियर वकिलाने कोर्टात काम सुरू केल्यानंतर एखाद्या चेंबरच्या, सिनियरच्या चेंबरला जॉईन व्हावं असं माझं कायम सांगणं असतं. आणि ते सिनियर कशा पद्धतीने ऑफिसमध्ये आणि कोर्टामध्ये काम करतात, वेळेची गुंतवणूक कशी करतात, या सगळ्या गोष्टी ज्युनियरने ऑब्झर्व करायला पाहिजेत. चेंबरमध्ये प्रॅक्टिस करावी, नंतर कोर्टात जावं हे अशासाठी की कोर्टात जे आपण काम करणार असतो त्याची बेसिक तयारी आपण आपल्या ऑफिसमध्ये बसून करत असतो. आपण ड्राफ्टिंगचं काम विशेषतः, मी फौजदारी वकील असल्यामुळे त्या संबंधाने सांगतो, अपिलाचं ड्राफ्टिंग आहे, बेलचं ड्राफ्टिंग आहे, प्रायव्हेट कंप्लेंटचं ड्राफ्टिंग आहे, रिव्हिजन ऍप्लिकेशनचं ड्राफ्टिंग आहे. आपले सिनियर कशा पद्धतीने करतात, डिक्टेशन तुम्हाला घेता आलं तर सोन्याहून पिळलं. आत्ताची नवीन पिढी आहे, कॉम्प्युटर सेवी आहे, एक्सपर्ट आहेत कॉम्प्युटर मधले, त्यांनी ते डिक्टेशन घ्यावे. तुम्ही डिक्टेशन घेता घेता सुधाराल. आणि शेवटी मग कोर्टात गेल्यानंतर सिनियर कशा प्रकारे काम करतात त्यांना फॉलो करणे. ते काम करत असताना आर्ग्युमेंट करतायत, क्रॉस एक्झामिनेशन करतायत. आता एक सरांनी, आव्हाड सरांनी सांगितलं की ते लिगल एज्युकेशन कॉलेज मधलं आणि प्रॅक्टिकल एज्युकेशन, क्रॉस एक्झामिनेशन तुम्हाला शिकवली जात नाही, एक्झामिनेशन इन चीफ कशी घ्यावी शिकवलं जात नाही, री एक्झामिनेशन शिकवली जात नाही, ती कुठल्या मुद्द्यावर घ्यावी हे सांगितलं जात नाही. तर त्यासाठी सिनियरचं ऑब्झर्वेशन करून त्याच्या त्या वेळेला नोट्स घेऊन सिनियरने जे सेक्शन्स रिफर केले त्याचं वाचन करून आणि सिनियरने जी सायटेशन्स कोर्टामध्ये दाखल केली इन सपोर्ट ऑफ हिज कंटेन्शन आयदर फ्रॉम दी साइड ऑफ अक्यूज ऑर फ्रॉम दी साइड ऑफ प्रॉसिक्युशन, ती सायटेशन्स काय परत वाचून घेणे, ते सेक्शन्स वाचून घेणे आणि शेवटी एखाद्या ज्युनियरने आपली युटिलिटी त्या सिनियरच्या चेंबरला आहे हे प्रूव्ह करावं लागेल की आय एम अ मॅन ऑफ यूज, आय एम अ मॅन ऑफ ग्रेट एड, I can find out the citations, I can get the drafting done. आपली युटिलिटी सुद्धा सिद्ध करावी लागेल आणि अशा प्रकारे आपण परफॉर्मन्स दिला तर तुम्ही प्रगती करू शकाल असं मला मनापासून वाटतं. धन्यवाद.
धन्यवाद गजानन चव्हाण साहेब. आता हे सगळं आपण ऐकलंय. चॅलेंजेस, तुमच्या समोर केवळ चॅलेंजेस ठेवावेत असा आमचा हेतू नाहीये. चॅलेंजेस आहेत परंतु संधी पण आहेत. आणि मग सकाळी सगळ्यांनी सांगितलं तुम्हाला की तुम्हाला अतिशय हार्डवर्कनी करायचं आहे, ते करताना पैशाच्या मागे फारसं काही जायचं नाहीये, पण पैसे तर मिळाले पाहिजे. शेवटी आपल्याला हे सगळ्यांना माहिती आहे की सगळं सैन्य आहे पोटावरच चालत असतं आणि व्यवसाय नोबल आहे, नोबल पद्धतीनेच काम करायचं आहे, पण चॅरिटी नाहीये. योग्य आर्थिक नियोजन सुरुवातीपासून झालं पाहिजे, ते केलं पाहिजे आणि त्याकडे देखील तुमचं लक्ष वेधणं हे मोठे भाऊ म्हणून, बार काउन्सिल म्हणून मला असं वाटतं की आपलं काम आहे. मी बार काउन्सिल ऑफ इंडियाचे आमचे सदस्य आणि ज्येष्ठ बार काउन्सिलर सतीश देशमुखांना विनंती करतो की ते या दृष्टीने तुमच्यासमोर एक विचार ठेवतील आणि त्या दृष्टीने ते सांगतील की हे आर्थिक नियोजन तुमची इकॉनॉमिकल डेव्हलपमेंट इन प्रोफेशन करण्याकरता तुमचा दृष्टिकोन कसा असावा.
मित्रांनो, जीवनामध्ये आर्थिक नियोजन फार महत्वाचं आहे. आर्थिक नियोजन यासाठी महत्वाचं आहे की आपण बघता की सिव्हिल स्कोर पाहिल्याशिवाय आपल्याला कोणतीही बँक लोन देत नाही. मग तो सिव्हिल स्कोर कशा पद्धतीनं आपला इन्क्रीज होईल आणि आपल्याला जीवनामध्ये सक्सेस व्हायचं असेल तर आर्थिक नियोजन त्यासोबत आपल्याला करावं लागेल. तुम्ही यंग आहेत, तुमच्याकडे बऱ्याचशा अपॉर्च्युनिटी तुम्हाला त्या टॅक्स मधून, इन्कम टॅक्स मधून तुम्हाला मिळणार आहेत. तुमची कोणतीही अपॉर्च्युनिटी ही तुमच्याकडे जर इन्कम टॅक्स पेड नसेल तर तुम्हाला मिळणार नाही. मग ते सरकारी वकील असतील, तुम्हाला ज्युडिशियल मॅजिस्ट्रेट व्हायचं असेल किंवा एखाद्या कंपनीमध्ये तुम्हाला लिगल ऍडवायझर म्हणून अपॉइंटमेंट व्हायचं असेल तर तुम्हाला 3 वर्षाचा इन्कम टॅक्स मागितला जातो आणि याचं नियोजन तुम्ही यावर्षीपासूनच जर केलं तर मला खात्री आहे की तुम्ही जीवनामध्ये निश्चितच सक्सेस होऊ शकता. त्यासाठी आम्ही इंडियन ऍडव्होकेट मल्टीस्टेट मल्टीपर्पज सोसायटीची स्थापना केली आहे. जिथे आमच्या शाखा आहेत तिथे आम्ही बऱ्याच वकिलांना लोन देतो. सेव्हिंग अकाउंट ओपन करतात, त्या अकाउंटमध्ये पैसे ठेवतात ते लोन घेतलेलं रेग्युलर ज्या डेटला भरायचं त्या डेटलाच भरून तुमचा सिव्हिल इम्पॅक्ट वाढवता येतो. तुम्ही जनरली बघता की तुमच्या पप्पाची गाडी तुम्ही यूज करता, पप्पाचं एटीएम कार्ड यूज करता. जीवनामध्ये तुम्हाला जर आता सक्सेस व्हायचं असेल तर आता तुम्ही बार काउन्सिलला रजिस्टर्ड झाले. बार काउन्सिलला रजिस्टर्ड झाल्यामुळे तुम्हाला जीवनामध्ये 5 वर्षाची सिनियरिटी मिळाल्यानंतर तुम्हाला अनेक ऑपॉर्च्युनिटी, 3 वर्षाची प्रॅक्टिस झाल्यानंतर तुम्हाला लाख रुपये, सव्वा लाख रुपयाची ऑपॉर्च्युनिटी महिन्याला मिळवायची असेल, ज्युडिशियल ऑफिसर व्हायचं असेल, सरकारी वकील व्हायचं असेल किंवा इतर बँकावर अपॉइंटमेंट व्हायचं असेल तर तुम्हाला तुमचं आर्थिक नियोजन करणं गरजेचं आहे. त्यासाठी तुम्ही स्वतःचं बँकमध्ये अकाउंट काढून एटीएम कार्ड तुम्ही स्वतःच्या अकाउंट मधून एक्सपेंडिचर करायला पाहिजे. लोन घेऊन मग ती छोटीशी व्हेकल असेल 50-60 हजाराची, ती तुम्ही लोनवर घेऊन त्याचे इन्स्टॉलमेंट तुमच्या पप्पाकडनं घेऊन जर तुम्हाला इन्कम नसेल तर तुम्ही ते सुद्धा रेग्युलर महिन्याला भरायला पाहिजे. या पद्धतीनं तुम्ही 5 लाख रुपयाचं जर नियोजन दरवर्षी इन्कम नसताना पण तुम्हाला इन्कम दाखवावं लागेल, म्हणजे की तुम्हाला 2.5 लाख होता आता 5 लाख झालेला आहे, तर हे तुम्हाला स्टेटमेंट त्या इन्कम टॅक्सकडे जाऊन भरावं लागेल. 1500 रुपये टॅक्समध्ये भरावं लागतील. या पद्धतीने तुम्ही जर नियोजन केलं तर मला खात्री आहे की तुम्हाला कोणीही जीवनामध्ये हरू शकणार नाही. एक छोटासा अनुभव तुम्हाला सांगतो की लाईफ इन्शुरन्सची पॉलिसी तुम्ही घेता. अनेक जण सजेस्ट करतात की लाईफ इन्शुरन्सची पॉलिसी घेतली म्हणजे तुम्ही डेथ झाल्यानंतरच ती तुम्हाला तुमच्या वारसांना मिळणार आहे. असा प्रकार नाहीये मित्र. लाईफ इन्शुरन्सची पॉलिसी तुम्ही काढल्यानंतर तुम्हाला ती जीवनामध्ये मिळू शकते. त्याचं उदाहरण मी आहे. मी माझ्या लाईफमध्ये 2 पॉलिस्या कंटिन्यू केलेल्या आहेत 15-15 वर्षाच्या, आणि भरपूर हँडसम अमाऊंट मला मिळालेली आहे आणि त्याच्यामुळे प्रोग्रेस झालेला आहे. एक तर सवय लागते, एक तर तुम्हाला तुमची गॅरंटी येते की माझा लाईफ इन्शुरन्स आहे, मी माझ्या कुटुंबाला माझं काही झालं तरी इतके पैसे माझ्या कुटुंबाला मिळू शकतात. पुढे भविष्यामध्ये तुमच्या मुलांचे एज्युकेशन आहेत, ते एज्युकेशन करण्यासाठी याचं नियोजन तुम्हाला करणं गरजेचं आहे. यासाठी आर्थिक नियोजन व्यवस्थित करा, हेच या प्रसंगी आम्ही तुम्हाला सांगू इच्छितो.
अतिशय आवश्यक अशी बाब आहे. इन्कम टॅक्स रिटर्न भरा, टॅक्स भरत चला. कुठलीही चांगली गोष्ट केली की आपण साधारणतः वा असा शब्द करतो. एका आर्थिक नियोजनवाल्या सल्लागारानं फार चांगलं सांगितलं की 4 वा व्यावसायिकांनी लक्षात ठेवावेत. पहिला वा असा आहे की आपल्याला मिळालेल्या उत्पन्नातून वाचवा. पहिला वा आहे वाचवा. दुसरा वा असा आहे की तो वाचवलेला पैसा वाढवा. तो कुठे गुंतवायचा चांगल्या पद्धतीनं, तो तिथे गुंतवा आणि तो वाढवा. तिसरा वा असा आहे की तो वाढलेला पैसा वापरा. आणि चौथा वा असा आहे की तो मिळालेला पैसा काहीतरी चांगल्या कामाकरता तुम्ही वाटा. त्याप्रमाणे हे ते वाचवा, वापरा, वाढवा आणि वाटा, या 4 वाहनकडे तुम्ही नक्की लक्ष द्या. सुरुवातीपासून लक्ष द्या. 50 वर्षानंतर लक्ष दिल्यानंतर फारसा काय उपयोग होत नाही मित्रांनो. त्याच्यामुळे आमच्या सगळ्यांच्या अनुभवाचे बोल तुम्हाला आम्ही या ठिकाणी एवढंच सांगू की सुरुवातीपासून काहीतरी बचत करा. आता आपण चॅलेंजेस मला असं वाटतं की भरपूर बघितलेली आहेत. आता यामध्ये संधी तर खूप आहेत. संधी चांगला वकील व्हायचे आहेत, चांगला दिवाणी वकील व्हायचे आहेत, चांगला फौजदारी वकील व्हायचे आहेत, कन्झ्युमर आहे, NCLT आहे, DRT आहे, ज्युडिशियल सर्व्हिस आहे, प्रॉसिक्युटर आहे, आम्ही तर सांगतोच आहे खूप मोठ्या संख्येने आहे. लीडर व्हायचं आहे, सांगितलं सरांनी पण की चांगले लीडर्स आहे निर्माण होतात. आणि खरी गोष्ट आहे, तुम्ही कुठल्या पुढाऱ्याला विचारा तो म्हणेल की आमच्यामधले पक्षातले असतील, असेंब्लीमध्ये असतील, चांगलं काम करणारा वकील असतो. त्यामुळे दृष्टिकोन मिळतो. तुम्ही कुठे जे काय आहे ते उत्तम करिअर घरा, संधी खूप आहेत. मी सगळ्यांच्या वतीने आवाड सरांना की आता या संधी ज्या आहेत त्यावर आपणच आपल्या अनुभवाने प्रकाश टाकावा, कारण वेळ होत आलेला आहे. त्यामुळे सगळ्यांना बोलायची इच्छा आहे, थोड्या वेळेच्या अभावामुळे मी आवाड सरांनाच विनंती करतो की आमच्या सगळ्यांच्या वतीनं या तरुणांना काय संधी आहेत याबद्दल आपण थोडंसं तपशीलवार मार्गदर्शन करावं आणि त्यांना प्रोत्साहित करावं.
नमस्कार मित्रांनो, खरं तर वेळ झालेला आहे, तरीही शेवटचे 5 मिनिटं घेतो आहे. मला सांगण्यात आलेलं आहे की संधी संबंधाने चर्चा करावी. भरपूर चर्चा झालेली आहे. मित्रांनो, मी यापूर्वी 44 वर्षापूर्वी जेव्हा वकील झालो तेव्हा कैलासवासी भास्करराव आव्हाड सरांच्या हाताखाली वकिली सुरू केली. तेव्हा असलेली वकिली आणि आता असलेली वकिली यातला फरक तुम्ही समजावून घ्या, आपोआपच तुम्हाला मार्गदर्शन होईल. आणि तेव्हा कोर्टात जाताना आव्हाड सरांनी सांगितलं की सगळे सायटेशन काढून ठेवा, बरे ढिगभर पुस्तकं घ्यायची आणि कोर्टात जायची. मित्रांनो, तुम्हाला आता याची जरुरी राहिलेली नाही. तुम्ही मंडळी आता ई सॅव्ही आहात, टेक्नो सॅव्ही आहात, तुम्हाला याची जरुरी राहिलेली नाही. तरीही तुम्ही कितीही टेक्नो सॅव्ही असला तरी एक उदाहरण सांगतो. संपण्यापूर्वी 2017 सालापासून चायनामध्ये, चीनमध्ये आता पूर्णपणे इलेक्ट्रॉनिक कोर्ट्स निर्माण झालेले आहेत की त्या कोर्टामध्ये आता ह्युमन जज नाही. अशी कोर्ट 2017 पासून चीन मधल्या 4 मुख्य गावामध्ये आहेत, 4 मुख्य प्रांतामध्ये आहेत आणि जवळजवळ ते पुढच्या 5-7 वर्षामध्ये संपूर्ण चीनमध्ये ह्युमन जज असण्याची गरज भासणार नाही. तिथे असलेले ऑफिसर सुद्धा हेही आता ह्युमन ऑफिसर्स नाहीत, तेही रोबो आहे. जर का जगभर अशी स्पर्धा चालू असेल, साहजिकच हे आपल्याकडे यायला किती वेळ लागेल. जसा व्हायरस 1 दिवसात आला तसा हा रोबोट सुद्धा 1 दिवसात येईल. मग आपण तुम्ही सगळी मंडळी त्याला तोंड द्यायला सक्षम असलं पाहिजे. मला मगाशी विचारलं की यशस्वी वकील होण्यासाठी काय करायचं असतं. मी एकच सांगेन, ज्याला सुंदर टायपिंग येते ना, जो आपल्या सिनियरच्या स्पीडने टाईप करू शकतो ना, तो सुंदर वकील होणार. तुम्हाला सांगतो, त्यासाठी मोठे लॉ लेक्सिकॉन आणि मोठी पुस्तकं वाचण्याची बिलकुल गरज नाही. याच्यानं सुरुवात करा. सिनियरच्या सोबत बसताना सिनियरला असं वाटलं पाहिजे, अरे हा माझ्या उपयोगाचा आहे, मला जे येत नाही, मला स्पीडीली टायपिंग करता येत नाही, तर मला याच्यासोबत हा माझं सगळं काम करतो आहे. तर मित्रांनो, तुम्ही त्या सिनियरचे आवडते ज्युनियर आपोआपच बनत जाता. हे सूत्र जरी लक्षात ठेवलं तरी तुम्ही यशस्वी होऊ शकता. अलीकडे 2 गोष्टी आहेत, 5 मिनिटं घेतो, की सगळीकडे फरक होत चाललेला आहे. जुन्या काळी बघा, चोरी व्हायची, खिसा कापला जायचा, दरोडा टाकला जायचा, मग आपला तो कॉन्स्टेबल काठी टेकत यायचा, कुठे तो गुन्हेगार. आता मित्रांनो, ही परिस्थिती बदलली. उदाहरणार्थ पुण्याच्या कासवास बँकेवरती ई दरोडा पडला आणि 450 कोटी रुपये परदेशात निघून गेले. आता तो जर का आपण दंड घेऊन त्या कॉम्प्युटर समोर गेलो आणि विचारलं कुठे गुन्हेगार, तर सापडणार नाही. थोडक्यात तुम्हाला आता इथून पुढे सायबर लॉ हा आत्मसात केला पाहिजे. की नवीन प्रोग्रेस होणारा फील्ड आहे. तुम्ही नेहमी वाचत असाल, अशाच प्रकारचे गुन्हे सध्या घडत असतात. मग उत्कृष्ट क्रिमिनल लॉयर होण्यासाठी फक्त IPC, CRPC वगैरे वाचून चालणार नाही, तर तुम्हाला सायबर लॉ व्यवस्थित समजून घेतला पाहिजे. दुसरं शेवटचं सांगतो की आता आपल्याला प्रत्येक गोष्ट आता इंटेलेक्च्युअल प्रॉपर्टी लॉ मध्ये कन्व्हर्ट होते आहे. प्रत्येक ठिकाणी तुम्ही पाहत असाल पेटंट्स, कॉपीराइट्स, ट्रेडमार्क्स आणि आता GI इंडिकेशन म्हणजे GI याचा वापर होतो. अगदी तुम्हाला हळद वापरायची असली त्या स्ट्रॉबेरीचं जर का ट्रेडमार्क स्ट्रॉबेरी मार्क वापरायचा असला तरी सुद्धा महाबळेश्वरच्या स्ट्रॉबेरीचा ट्रेडमार्क तुम्हाला GI मार्क तुम्हाला जगभर घेऊन जातो. ते हळद तुम्हाला जगभर घेऊन जाते. कोल्हापूरच्या चपलाचा GI तुम्हाला जगभर घेऊन जातो. हे सगळं शास्त्र तुम्ही समजावून घेतलं पाहिजे. म्हणजे थोडक्यात तुम्हाला मॉडर्न टेक्नो वकील होता येईल. मित्रांनो, यापेक्षा जास्त सांगणं बरोबर होणार नाही. आता मी बार काउन्सिल मध्ये नाही, ही सर्व मंडळी बार काउन्सिल मध्ये आहेत. खुर्चीवर नसलेल्या माणसाला, खुर्चीवर असलेल्या माणसाला काही प्रश्न विचारता येतात आणि म्हणून जाता जाता मी तुम्हा सर्व ज्युनियर वकिलांच्या वतीनं त्यांनाच एक प्रश्न टाकणार आहे. आता पॅन्डेमिकच्या काळामध्ये आपण परिस्थिती अनुभवली, अत्यंत अडचणीची परिस्थिती होती. विशेष करून ज्युनियर वकिलांना खूप अडचणी होत्या. बार काउन्सिलने मोठी मदत केलेली आहे, आम्हाला माहिती आहे. आमच्या पुण्याच्या मेंबरनी तर खूप छानच काम केलेलं होतं, सगळ्याच मेंबरनी. परंतु या पार्श्वभूमीवरती आपण बार काउन्सिल ऑफ इंडियाचे उपाध्यक्ष इथे आहेत, असा एखादा कायदा राज्य मंत्रिमंडळाच्या मागे लागून किंवा केंद्रीय मंत्रिमंडळाच्या मागे लागून संसदेतून किंवा आपल्या इथल्या कायदेमंडळाकडून जर का आपल्याला तो पारित करून घेता आला
की ज्याद्वारे आमच्या ज्युनियर बांधवांना काहीतरी मदत करता येईल आणि ते कायमस्वरूपी राहील, तर मला असं वाटतं की आपल्या हातून खऱ्या अर्थाने पुण्याचं काम होईल. धन्यवाद.
आपण आता या चर्चासत्राचा समारोप करतो आहोत. We started with English. We concluded with Marathi. Language is not a barrier. It's only the media for communicating properly. And particularly in a field of law, we are doing a work for justice. And justice is to be done for the litigant. Litigant is ultimate consumer of this entire process. तो एक आपल्या मनामध्ये सतत भावना ठेवली पाहिजे की आपण कोणासाठी काम करतोय, स्वतःसाठी करतोय, कोर्टासाठी करतोय, समाजासाठी करतोय की व्यक्तीकरता करतोय. त्या आलेल्या अशिलाला न्याय मिळवून देण्याकरता करतोय आणि मिळवून देणारा न्याय हा समाजासाठी आहे, तो त्या व्यक्तीसाठी नाहीये. कारण आपण सगळ्यांनी ऐकलेलं आहे, जस्टिस इज नॉट टू बी डन, जस्टिस मस्ट बी सीन टू बी डन. समाजाकरता न्याय असतो. त्या दोन व्यक्तींमधला जरी तो निवाडा असला तरी समाजामध्ये हे प्रस्थापित करायचं असतं की असा असा वाद झाल्यास असा असा न्याय होईल. त्याच्यामुळे मित्रांनो, तुमचा रोल जो आहे तो आता कुठल्याही एका बिझनेसचा नाहीये, तो एका वेगळ्या अशा व्यवसायाचा आहे, ज्याला मराठी भाषेमध्ये पेशा म्हणतात, इंग्लिशमध्ये प्रोफेशन म्हणतात, नोबल प्रोफेशन म्हणतात. आणि तो आता नोबल प्रोफेशन आहे की ज्याच्यावर जबाबदारी अधिक आहेत आणि हक्क कमी आहेत. त्याच्यामुळे आपण एका समाजसेवकाच्या भूमिकेतनं ही सनद घेतलेली आहे. त्या सनदीची ज्या काही जबाबदाऱ्या आहेत त्या जबाबदाऱ्या आपण पार पाडाल अशी आम्हाला खात्री वाटते. आपण सगळेजण इतक्या मोठ्या संख्येने आलेले आहेत. मी शेवटी आमचे अध्यक्ष गोवर्धीपांना आपले आभार मानायला विनंती करणार आहे. आणि या चर्चेतनं जे काही आपल्याला आपल्यापर्यंत पोहोचलं असेल काहीतरी, त्याची मला खात्री आहे, ते तुम्ही सांभाळून ठेवा. पुढच्या येणाऱ्या कार्यक्रमात शक्य झालं तर फिजिकली आणि नाही शक्य झालं तर व्हर्च्युअली आपण सातत्याने भेटत जाऊ अशी आपण खात्री बाळगा. जे विषय आपल्या समोर आहेत त्या विषयाचं पण आपण हे करणार आहोत. आणि दुसरी गोष्ट, आज जे 2 पुस्तकं प्रकाशित झाली त्या दोन्ही पुस्तकांची पोच तुम्हाला घरपोच मिळणार आहे. कुरिअरनं 2020 जानेवारी 2020 पासून एनरोल झालेल्या प्रत्येक वकिलाला ते बार काउन्सिलच्या मार्फत कुरिअरनं पुस्तकं दोन्हीही आपल्या घरी येणार आहेत. त्याचा उपयोग आपल्याला करता येईल. ते अतिशय उपयुक्त अशी पुस्तिका आहे. आणि येणाऱ्या लवकरच्याच काळामध्ये व्हॉट इज बार काउन्सिल, बार काउन्सिलचे रूल्स रेग्युलेशन्स काय, हे एक पुस्तक. आणि सकाळी जे सांगितलं की प्रॅक्टिस मला दिवाणी प्रॅक्टिस करायची, फौजदारी प्रॅक्टिस करायची, कन्झ्युमर प्रॅक्टिस करायची, त्याबद्दलचं मॅन्युअल, अशी अधिक 2 पुस्तकं देखील 2020 पासूनच्या सगळ्या नवीन एनरोल ॲडव्होकेट्सना बार काउन्सिल मार्फत घरपोच मिळणार आहेत. त्याचा आपण वाट पहा, त्याचा अभ्यास करा. आपण सगळेजण आलात. मी आमचे सन्माननीय अध्यक्ष अनिल गोवर्धींना सांगतो की आपल्या सगळ्यांचं या ठिकाणी पुन्हा एकदा स्वागत करावं या व्यवसायामध्ये आणि पुन्हा एकदा त्याचे आभार देखील मानावेत.
मित्रो, आज सकाळी 11 वाजेपासून बेसिक लीगल एज्युकेशन प्रोग्राम याचं उद्घाटन सन्माननीय न्यायमूर्ती अभय ओक साहेब, कर्नाटक उच्च न्यायालयाचे न्यायमूर्ती, मुख्य न्यायमूर्ती, तसेच आपल्या मुंबई उच्च न्यायालयाचे न्यायमूर्ती, मुख्य न्यायमूर्ती दत्ता साहेबांच्या हस्ते पार पडलाय. मित्रो, हे मागच्या वर्षीपासून आपलं पॅन्डेमिक कोविड हे जे असल्यामुळे बरंच आपल्या वकिलांचं फार मोठं नुकसान झालेलं आहे. कोर्ट कचेऱ्या बंद आहेत आणि हे किती दिवस चालेल हे आज देखील आपण काही सांगू शकत नाही. मी आता आमचे सर्व सन्माननीय सदस्य हे सगळे आज इथे या कार्यक्रमाला एकत्र आले, त्यांचा मी फार आभारी आहे. आणि त्यांच्यामुळे आपण या ज्या कार्यक्रमाची सुरुवात केलेली आहे, आता याच्या पुढे हे आपलं जे पॅन्डेमिक जे आहे हे किती दिवस चालेल, त्याच्यावरती आपल्याला काय तोडगा करता येईल आपल्या प्रोफेशन मध्ये, याचा देखील विचार करून एक लवकरात लवकरच आपण एक वेगळा अजून कार्यक्रम आयोजित करू आणि जेणेकरून आपल्या वकिलांना घरून देखील कामं करतात तशी करता येईल याचे नियोजन करू आपण. याच्या व्यतिरिक्त काही तुमच्याकडनं सल्ला असेल, काही एक आयडिया असेल तर तुम्ही ते आमच्या याच्यावर टाका तुम्ही मेसेजवर, आणि तो देखील विचार केला जाईल की नवीन टेक्नॉलॉजी म्हणजे आपल्याला कसं इथे चालता येईल पुढे. मी सगळ्यांचा आभारी आहे. आज आपण सगळे नवीन लॉयर्स या फंक्शनला जॉईन झाले आणि आपल्या सगळ्यांना मी या माध्यमातून शुभेच्छा देतो आणि आपल्या आयुष्यात पूर्ण पुढे वकील व्यवसायामध्ये आपल्याला यश मिळो. धन्यवाद.
Thank you, everyone. This concludes today's program. All the participants who are watching on YouTube as well as in the Zoom room, kindly check your emails. All the further updates will be provided via emails, as well as messages will be forwarded to your registered mobile number with Bar Council of Maharashtra and Goa. So, with permission of Honorable Chairman, we are ending today's session. Thank you all for participating.
हा इथे लक्ष असू द्या. तसंच थांबा, तसंच थांबा. एक सेकंड.